Labrīt. Mēs varbūt
Dear ladies and gentlemen, I think it's a high time to start. I'm very happy to welcome you to this conference today. We are happy to have co-organized this conference together with the European Judicial Academy. And in recent years, our cooperation with the European Judicial Academy has become very important for us, and we have built a close cooperation with the Academy. And 3 years ago, at the end of the 2016, we also joined the Council of the European Judicial Academy. By being members of this council, we can also contribute to the content of the work of this academy, and we are happy to have been or to be involved in the work of the academy, and we often attend various training in Trier organized by the academy. And 3 years ago, we also signed a cooperation agreement with the European Judicial Academy for hosting a series of seminars. We have already had 20 seminars in Riga already, and there are 20 or so more to go in future. And our colleagues very much appreciate, and we have very positive feedback about different workshops. However, today we have a special conference. Today's conference is more of a workshop for exchange of ideas on a crucial issue for the judicial system, the judicial independence and judicial independence of individual judges, which is very important in the present context. We would like to talk about the case management issues and the communication with the society, and we would like to this is a workshop because it is a combination of theoretical approaches as well as practical measures for ensuring the independence of judges. And we organized a conference together with Professor Heusel, and he is one of the co-organizers here. But now I'd like to give. Dear Justices, dear guests, dear ladies and gentlemen, let me thank everyone who responded to the invitation to attend this and other conferences and workshops organized by us. Thank you for contributing to a better judicial system, to more efficient courts, to making life better and bringing justice to all the inhabitants of Latvia. Judges are independent and have to follow only the law. Judicial independence is one of the core elements of democracy. And this core element is balance between three branches of power and efficient coexistence of three branches of power, as well as bringing justice to the society. So judge is the key person in the judicial system. Judge is responsible for the constitutionality, legitimacy of the court decisions and enforcement of other legal acts. Judges ensure the fundamental rights of each and every individual, and they ensure people's rights to fair trial. And to me, it seems that to be independent and be responsible for core values of our society is not easy. It is always easier to work within the framework of the law, and you can always say that the law does not require this of me, or this is what the law requires, or basically follow the minimum requirements of the law. Whereas independence goes a lot further beyond, so you have to be able to aim higher, you have to be able to work independently according to the spirit of the law. And various branches of the government control each other as well as protect each other in order to achieve balance and the efficiency. And this is how we ensure that there are no vested interests dominating or ambitious minds dominating our system. And judges ensure a fair trial and fair proceedings. According to the principle of independence, judges and courts are institutionally independent or enjoy institutional independence, and only if courts are autonomous and independent will they be able to achieve their objectives to strengthen the public trust in courts. Judges must show by what they do and how they behave that they meet the highest ethical and professional standards. So by being unbiased and being honest and fair, you become a good judge. And judges should be free of any pressure of the government. Judges represent the people, so they have to follow the best interests of the people as much as the government. And you have to treat others as equals, and this may sound very trivial, but we have to be closer to the people, and it is a very important aspect of judges' work, being close to the people. And in order to ensure the balance in the judicial system, after lengthy discussion, we have come to an understanding that judges should not be immune towards administrative penalties. So if a judge has violated administrative law, they can be punished or sanctioned just as any member of the society. Undoubtedly, most of the people perceive courts through media reports. I think that judges should communicate more information about the cases, no matter what the cases are, whether it is an acquittal or a conviction. We have a communication strategy was drafted 4 years ago, and it is currently being implemented. One of the communication strategy objectives is to promote the awareness of what the courts do and fairness principle in the work of courts, and we have to expose or we have to highlight the notion of fairness in the public communication as much as we can. And there's a lot to be done, but we are headed in the right direction. So I wish you all a constructive discussion on this topic or the topic of your presentation. I hope that you will find new angles, new aspects about the topic that you will present, and hopefully you will be also encouraged to think about the implementation of these principles in your practical work.
Dear Minister, dear Chief Justice, dear colleagues in the audience, I say colleagues because I'm myself a judge who has been on leave for many years in order to work for the Academy of European Law in Trier. And dear co-speakers, welcome to this conference, which we have had the pleasure to prepare in cooperation with the Court Administration of Latvia, with whom we have been cooperating in a wide field of European law, in wider fields of European law for the last 3 years, as Anna Skabina has highlighted. I would just like to say 2 sentences about my institute. It is the Academy of European Law, not the European Judicial Academy, as has been translated. I don't know whether that is perhaps because in Latvian the version is also about a judicial academy, but our remit is really all the legal professionals. So we try to address all legal professions in the European Union. The institute has been set up in 1992, so it's 27 years old, in the great context of the Single Market Initiative at the time, when even in the old member states, everyone became aware that there is a need to train legal practitioners on that new area of European law, which so far had just been theoretical and practical only for very few experts. But as we all know, that's very trivial nowadays. It is so important for everyone who practices law in any of the member states to know about this huge piece of law in order to make it effective and to make it also work for the citizens and for the enterprises. Now, with regard to our conference, the initiative to have a conference on that topic, that very important topic for the judiciary and also for the functioning of the state and for society, the independence of justice running through as a red thread through the program, went back to a conference we organized last year in Paris in cooperation with the French Cour de Cassation, the Court of Cassation, which addressed the same topic on a slightly different focus, but nevertheless, the independence of the judiciary as a cornerstone of also the functioning of the European legal or judicial system. And that is how we have then devised the program. As you see, the major part is really on judicial independence as such, looking at, first of all, general standards, then having two panels, one panel looking at the role and the importance of judicial independence for the functioning of the judicial system of the European Union, and the second panel more on very important technical or managerial or institutional issues, much of a practical relevance, which is just referred to as a contrast, an alleged contrast between ensuring the institutional independence of the judiciary and through this also the individual judicial independence of the individual judge. And then in the afternoon we will have two other very important focuses for judicial work as such, and that is the relation, the interaction of the courts and the judges with media. The Minister has touched upon that in his speech as well. And part of that, in a sense, is also the presence of the courts and the judges on the internet and how you should or could or may behave there. You have seen the program, and I hope that we will, by devising it that way, serve your interests. And that means that we also hope very much for an interactive session, that you come in at any stage with questions and comments. Don't hesitate to even interrupt if you have an urgent question, but certainly bring in your views, bring in your positions, your experience at any time of the discussion so that we have an exchange. It is, as the Minister said, in that sense, it's really a workshop, and the size of the audience and the setting of the room, I think, invites for that as well. That is my introduction at that stage, and I'm happy to introduce as the first speaker Lorena Bachmeier-Winter, who's sitting here, who is a professor at the Complutense University in Madrid. She has acted as an expert to the Council of Europe and the European Commission in different aspects. She is an expert in procedural law in general, and she will address the international standards guaranteeing judicial independence. She will speak for about 40-45 minutes, more or less, and then we will have an open discussion before we break for the first time. Lorena, you have the floor. Thank you very much, and enjoy the conference.
Thank you very much, Wolfgang, for this very nice introduction. Thank you for the Latvian authorities, for the courts, for inviting us, for organizing this seminar. And thank you all of you for being here. So good morning. I hope after 45 minutes you are not absolutely bored by the topic, and at least we will be ready for the coffee break. I want to insist, as Wolfgang already said, please jump in and come with any questions, because most of the issues I might be presenting are already very much known to you. I was asked to present on the Council of Europe standards. Council of Europe standards and the role of the Venice Commission. So I'm not entering into the precise topics on the relationships with the media, which are very much connected with judicial independence and the trust of the society in their court system and in the judges. And I won't enter into discussing the recent problems we are facing in several European Union and non-European Union member states of the Council of Europe, and with regard to the judicial independence. I will introduce them into the discussion, because I think it's very important for all of us to reflect on not only what these standards are, which is good to recall which are the standards we're talking about, but also how to implement them. I've been working already for 10 years in implementing projects on transitional democracies, implementing rule of law, and precisely setting up democratic, reliable, and independent justice systems, because that's the cornerstone of every democratic system, and obviously the rule of law. After these 10 years, traveling around many countries, from Kyrgyzstan to Venezuela, lately not so much in Venezuela, and I can tell you the challenges are huge. We may agree on the concepts, we may agree on the significance and importance, but there is still a lot of problems in getting implemented the judicial independence. So today I'm focusing only on the European standards. Very briefly, you know very well the judicial independence is safeguarded, is recognized and set out in Article 6.1 of the European Convention, and in its mirror, Article 47 of the European Union Charter. And why is it important today, nowadays, to discuss and keep on discussing on judicial independence? Not only because it's threatened every day, every judge, in some way or another, experiences pressures. Important thing is that they have mechanisms and safeguards to resist those pressures. First, because obviously it has a huge impact on the concept and the implementation of the rule of law. And within the European Union, it's being discussed how to really approve and put in place effective mechanisms to make the rule of law really effective, compliant. Because what we have been seeing with regard to two countries, I won't blame and shame, but you all know we are talking about precisely Hungary and Poland, but lately more Poland. Since 2015, is there general deficiencies on the rule of law precisely related to the judicial independence. And the mechanisms of the European Union have not been the responses, the infringement procedures, the diplomatic approaches, the letters, the reasoned letters have not been enough to overcome these problems. And in the annual growth survey of 2018, stability, security, and rule of law is so important for the economic growth. So it's a real target for the European Union to address these issues very seriously. And as long as they are not effective, as long as rule of law is not compliant with, the rights of the citizens are not being adequately protected, and moreover, the targets of the European Union might not be complied with. Second, obviously, because there is an infringement of our constitutional values, and if we are strong, or we're very proud in the European Union of our own democratic values, our solidarity, our principles of the rule of law and the protection of human rights. If we are losing that, then Chinese is gaining the battle in commercial, in the commercial field, and the other ones are the big ones in military power. So European Union has to stick very strongly to the democratic values and the protection of human rights. And obviously because this poses direct threats on the whole area of security, freedom of justice, because if in one of the countries rule of law is not being complied, judicial independence is not safeguarded, the mutual trust, the principle of recognition may not function as smoothly as it should. So we are dealing with huge risks. And this was, and the last risk, which is a major one, the growth of populism. And this was addressed in this report by the Secretary General of the Council of Europe. It's already 2 years ago, 19 May 2017. It's a broader report, but it addresses also the importance of judicial independence in how far this populism is able to undermine also the judicial independence. And you won't believe, but so long and lengthy established countries like Germany, they are considering themselves also, if the checks and balances in their own country, in their own judiciary, are strong enough to face possible populists coming into government. And something we considered absolutely unreal, absolutely far away from the reality in the core of the European Union, we are facing now these populist, extreme radical movements entering into several governments. So in this analysis of the democracy, human rights, and rule of law in Europe, based on the, sorry for the typo, findings on the monitoring mechanisms, shows already that we should be very alert and thinking of what the judicial independence means and how to improve the safeguards. So it has been mentioned, and it's obviously important to recall here, that judicial independence is one of the elements, if not the premise, the prerequisite of talking about the rule of law. And I like also to recall this very simple but so important statement made by John Locke in the Two Treatises of Government back in the 17th century, whenever law ends, tyranny starts. And we're talking about one of the founders of this idea of the checks and balances and the division of powers, although John Locke in the third division of powers did not mention the judicial power, but the federative power. But John Locke was so much influencing later Montesquieu, and Montesquieu was, we all know, obviously, the main defender of the idea that if the state doesn't detain itself, then the abuses, the discretion, and the tyranny goes rampant. So we are not talking about something, a new idea. So in the laws of Plato, and we're talking a 4th century before Christ, the idea of sticking to the rule of law, although not connected to the judicial independence, because obviously the modern state was not in place there, was already present. And I like to recall that 4th century before Christ, Plato already mentioned the collapse of the state, where the law is subject to some other authority and has none of its own. It's important to rethink this again and to be very aware of the importance of judicial independence for the rule of law. What is it? I'm going very, very quickly, long definitions, because you all know what judicial independence means. And I think this is quite a normal and very usual definition. Means the judiciary is free from external pressure and is not subject to political influence or manipulation, in particular by the executive branch. This is a requirement integral for the fundamental democratic principle of separation of powers. Why I'm mentioning here this definition? There are hundreds of definitions, much more accurate, others putting the focus more on the independence from the executive, others from the internal independence, others from outside pressures from the economic power, whatever. I'm bringing here this because when assessing, and I will come later to what is important nowadays within the European Union, is to know how can we really assess, evaluate if the judicial independence is being complied with or not, in how far a country, a state, is really adhering to the principles of the rule of law when it comes to judicial independence. Because I think this is one of the main challenges we are facing now. It may be easy to say, what is judicial independence? It is easy to say it is absolutely significant, important, indispensable for the rule of law. but it's not easy to say when we are facing absolute breaches or threats to the judicial independence. And in that sense, going back to this checklist, Venice Commission has established, following Lord Bingham, elements or ingredients or to identify the elements that define the rule of law. Venice Commission elaborated this rule of law checklist, which may be criticized or not, but I think it's a very useful toolkit in order to state one country is complying with the rule of law or not. At least look at these elements. And in this checklist that was approved in 2016, obviously judicial independence is one of the key elements, and it's defined in this way. It's important not only to say, not dependent from the executive, that's pretty clear. But the last point, is it a wishful thinking? Judges should not be subject to political influence or manipulation. Of course not. But how to ensure this is not going to happen? Judicial independence and the elements you perfectly know. Independent from what? From the executive, from the parties, from the legislature, except in applying the law. And absolutely, and this is another point, from any other external or internal influence. And we are facing in so many countries, through the appointment and recruiting system of judges, as well as in the regulation of their career and promotion, that the internal independence is not safeguarded. It's as good as well as it should, because mostly junior judges tend to follow the instructions, not given directly, because that would be against the European standards and their own national laws, but they tend to follow very strictly the advices by the superior judges or by the president of the courts. So there is a strong failure in many countries on the internal independence. So junior judges, in a high percentage of cases, do not feel they can really discuss, oppose, or object their superior or their presidents. Coming to Council of Europe standards. Council of Europe standards, before I enter into them, it's important to recall what is the purpose. We have defined, it's important for the rule of law, we have defined what it is, the different elements, but we have to always keep in mind that it's not a goal in itself. It's to guarantee every person the fundamental rights, not only to access to court, but to have their cases decided in a fair trial, only on legal grounds and in an impartial way and without improper influence. Independence of the single judge, independence of the judiciary is essential for each citizen's protection of their rights and for the checks and balances of the democracy. Now let's come, these are the four elements everyone agrees upon that should be in place to safeguard the judicial independence. How the judges are recruited, they are appointed, the term of office, irremovability or tenure is the ideal one, the safeguards, again, against any outside pressure. And here is a point that we tend to forget. And this is the tricky way states play upon the judiciary. Budgetary measures. So, okay, you will be independent. Okay, you have all the power and the last say upon conflicts, even against the state, even against the government. But I'm sorry, I'm making you as much inefficient as possible by reducing your budget as much as possible. And that sometimes is considered, oh, we don't have enough budget. Oh, we're lacking resources. We will see that this is an attack against the independence. And this is an infringement of the European standards. Finally, whether the judiciary appears as independent and impartial, not only by the way of recruiting, not only by interferences by high councils of justice, but also, and this is something that will be discussed later today, and I think it's a core element, which is the relationship with the other institutions, other powers of the state, but also with the media. Because the perception the population, the citizens have of the judges, it's not by being court users, that's a minority. But the trust in the judiciary is so much able to be manipulated by media and thus those who control the media. So that's an ongoing discussion. I will come later because I know in this country you approved back in 2015 or 16, I can't remember, a strategy on the communication. And this has been very much promoted by the Council of Europe Action Plan, because otherwise the judges are not able to voice out themselves what their role is being in the society and how important or how well their judgments are. These are the Council of Europe standards. So I just introduced here a list. I would say the main standards. Getting back to 1994, the recommendation of judicial independence, which was updated later in 2010. And of course, the European Charter on the Statute of Judges in 1998. I'm not going through all of them because you're perfectly aware of them. What is important to state here is all of them, of course. Like in your constitution, I remember Article 83 and onwards in Latvian constitution, all constitutions have a declaration, a recognition of the judiciary shall be independent. Even the Russian constitution has it. And the Ukrainian constitution too, where all of the judges were dismissed in 2014 for lustration. And again, last September, all Supreme Court judges were dismissed for a reorganization of the court system. So the point is, of course, this is an additional constitutional safeguard. But let's come into the details. These standards, the standards are set out in these very important documents, and I will focus on Council of Europe recommendation of 2010, which introduces and really lists a very detailed list of elements that should be in place to consider the judicial independence is respected and safeguarded, and obviously the role of the Venice Commission. So, Venice Commission, these are the main documents of the Venice Commission on independence on the judicial system, which we use continuously in all countries I work in order to implement judicial independence. This should be our rule book, no? The reports of the Venice Commission and, of course, the recommendations plus the case law of the European Court of Human Rights. And there is a very useful compilation of the Venice Commission opinions, if you are interested in it, because it introduces I wouldn't say a summary, but the main findings or the main statements Venice Commission has done when preparing opinions in the different countries. So this compilation, you find statements made with regard to Moldova, with regard to Poland, with regard to Ukraine or Montenegro. And it's been updated since 2010. So why are they so important, the Venice Commission opinions? Because contrary to these standards, which are general and abstract, the Venice Commission opinions enter into precise legislative assessment, constitutional issues, and context-based analysis. So upon countries And I've been able to work also with the Venice Commission in several joint opinions. And it's interesting when the state requires these opinions is the analysis we make ex ante, so in how far this draft law complies with the European standards or not, and ex post. So it provides really a broad picture on the issues raised with regard to any kind of constitutional problem. We are talking today on judicial independence. Well, these are the standards. Very quickly, I'm going just for you to know external independence. How is it defined? Obviously, it's not a prerogative or a privilege, but in the interest of the rule of law as a warranty of freedom. This external independence is always very much discussed by constitutional scholars and in general by constitutionalists, precisely when we are addressing US or American doctrine, because there's always a discussion on the democratic legitimation of the judges. Well, judges are not elected in our systems. Is this a prerogative that they are above the law, or they are really exercising powers which have not been sealed by the democratic legitimation? The approach, and this is what the CCJE and its opinion on judiciary and its relationship with the other powers has very well set out, is it's a functional legitimation. So the legitimation of the judiciary is and needs to be reaffirmed in every judgment. And this is why it is so important that the judgments are very well motivated, that they are public, but also, again, with the media, that they are very well explained to the citizens. Point 18 on the recommendation poses a lot of problems. What is the scope of the executive and the other powers, the legislative, when commenting upon judgments? They should avoid, this is what the recommendation says, they should avoid criticisms that would undermine the independence or the public confidence in the judiciary. They should also avoid actions which may call into question their willingness to abide by judges' decisions, other than stating their intention to appeal. Well, it's very rare, except that very few countries, that the executive refrains from commenting judgments they don't like. There's usually very not direct, not open, not manifest, not obvious, but there is criticism against the judgments, obviously, against those that are against the government, regional governments also. We are seeing that in Spain. But in general, politicians, if they don't like the judicial decisions, they usually use the press to criticize them through journalists, not directly. But this is the way you always, you are very well aware that this is happening, and this happens all the time. Except for France, that has specifically a criminal action, so criminal offense for those commenting, criticizing openly the judicial judgments. The others just try to say refrain from commenting, but no consequences are in place. The only consequences is the relevant judge or the judiciary, through its representative bodies, will make an open statement saying this is an interference, please stop doing it. But with very various impact on politicians. This is already commented. Internal independence, I already mentioned it. Each individual, including authorities internal to the judiciary, should not undermine the individual independence. Here I will comment later, because in practice, every individual judge faces the difficult position and the difficult situation of being absolutely independent from the superior, but on the other side, risking or fearing to enter into the disciplinary offense, disciplinary warning, disciplinary sanction by the superior if he does not if he does not act in compliance of the indications of the superior. Anyhow, superiors should not address instructions to judges, but sometimes it's not necessary to instruct. The lower court knows, or the lower judge or the younger judge knows exactly what they should do or not do, because they are already trained to follow, in some countries, the indications of the superiors. This is a very much discussed issue, the role of the councils for the judiciary in ensuring the independence of the judiciary. What the recommendation in the European and the Council of Europe Standards is, there's leeway for each state to decide how to ensure the self-governing bodies, how to organize them, how to structure them. The only thing is there is a preference for establishing councils for the judiciary, and if those are established, at least half of the members of such councils should be judges chosen by their peers. We can enter into this discussion later, and if they are fulfilling properly their role, or in centralizing the protection of the judiciary in one self-governing body, does not make it very much vulnerable to the states, the government, the executive, to try to influence directly the Council for the Judiciary. There's an ongoing now debate at the supranational level in how far these councils are really performing adequately their role in protecting individual judges and the judiciary as a whole. Obviously, common law countries have a different model. Germany hasn't got a council for the judiciary, although they are thinking now themselves as it might be good and might be positive to have it. Safeguards. Safeguards, it's obviously for the judicial independence stems from the moment of the selection and the promotion of judges. And there we find very many different systems on how they are selected, either a memoristic examination, just getting out of university, otherwise coming after practice, or in a mixed system. And the idea is, and this is very tricky too, the standard is selection shall be done upon objective criteria. What is objective criteria? Or how to ensure that subjective criteria are not in place when appointing a judge. I would say this is almost impossible. As long as you introduce an interview, as long as there is a psychological test, there might be certain subjective criteria. And but anyhow, we can discuss on this because the last 3 years I've been working on how to ensure that objective criteria are applied in appointing around 6,000 judges in Ukraine and a shorter number in Moldova. And still we are discussing on these objective criteria. I leave it for the discussion later because otherwise it will be longer than 45 minutes and I'm very bad on this. The authority, who shall take the decisions on the selection? Obviously, it should be independent. Who? The council? That would be the ideal if they are independent. But if the majority is appointed or is keen to the politicians, then we have a problem. A mixed composition seems to be the ideal, so that none of the fractions may be taking the lead, no? With a view to guaranteeing independence, half of the members of the authority selecting, so the recruiting and selecting body, should be judges selected by their peers. This leads again to a certain corporativism or risk of corporativism or a risk of nepotism. I can tell you about Bosnia-Herzegovina, which has the most safeguarding system with regard to judicial independence I've ever seen. So there was such an interest and effort that the judiciary is independent, that they really cannot be touched. And what has ended up, that they have become a close power, almost not accountable to anyone, and introducing their elements of their own corruption through nepotism, of course. So this balance is always very, very complicated. Tenure and irremovability. Of course, you are appointed for life, like in the States, or you are appointed up to retirement age. That's a key element of independence. Now we are seeing that it has to be legally provided, and the retirement age has to be set out in the law. What are we seeing right now in some countries? We change the law, and we lower down the retirement age, and we are still complying with the European standards, but we are interfering or getting rid of certain judges, experienced judges, senior judges, non-subservient judges, and just change the law if you have the majority in parliament and you get rid of them. So every system can be twisted. We are talking here about minimizing the risk. And it should be established by the law, again, but the law should also respect, so to say, acquired rights. So a transitional period for implementing a law, getting rid or dismissing judges, should be introduced in every law that pretends to lower the retirement age. What is the challenges here is always to the balance, finding the right balance between independence and accountability. And in that point, we are seeing a lot of risks, precisely through the devil is in the details. So we establish constitutional guarantees, we establish self-governing bodies, we provide for internal, external independence, but then we introduce certain disciplinary proceedings that might work, if not to end up dismissing a judge, which would be very, very obvious, that act as a kind of spade of Damocles. If you don't behave like the disciplinary commission likes, you may face sanctions. I'm talking about the criticisms, okay? I'm talking about the risks. And to that end, there's a lot of Council of Europe action into providing that these disciplinary liability proceedings are really compliant with the standards that were defined already in the judgment, the benchmark case on Alexander Volkov versus Ukraine of 2013. This Supreme Court judge, I'm not discussing if he was corrupt or not. I have my own opinion, but Alexander Volkov, Supreme Court judge, was dismissed without any fair trial rights by a body which was not independent. So disciplinary proceedings and disciplinary offenses shall be regulated as precise as possible. This goes back to the Consultative Council of Justice of the European Judges #3 opinion. Disciplinary proceedings shall be precise, so to grant foreseeability, provide for proportionate sanctions, fair trial rights in the proceedings, and an effective remedy before another independent judicial body. So, and in any case, not checking the content of the judgments, unless there's certain leeway, there is malice or gross negligence, because sometimes it's only in the judgment that it sees that there might be a corrupt conduct or misconduct of the judge. And these collegiate bodies shall be made of a majority of judges, so not dominated by the members of the executive or legislative branch. And this is the problem we are facing now again in Poland. There may be a majority of judges in the appointed disciplinary commissions, but they are still appointed with a huge influence of politics. So these are the challenges. I'm about to finish, don't worry, 5 minutes. And these are the standards. We can talk and talk about them, how to implement them, how to ensure them. And there's still this report of the Council of Europe of 24 March 2016. They are defining, identifying what are the challenges for the judicial independence. I think it's interesting to see the report on compliance with the recommendation 2010-12, not because I was in charge of writing that report and making the assessment where questionnaires were sent out also to Latvia, asking in how far they have implemented every one of the points of the recommendation of 2010-12. And it was very funny to see. I cannot, for confidential reasons, although the report is public, but not the country reports. But it's interesting to see that the most critical ones were the most advanced democracies. So in their own assessment in how they were complying with the judicial independence safeguards, Finland were very critical with themselves. Sweden were very critical with themselves. As other countries back in the south, we are saying we are doing our homework perfectly. Even other authoritarian countries I'm not mentioning, but you know whom we are talking to. So this report gives us an overview on the implementation, and now there's an action plan going on. And my question here, and this would be my last reflection on judicial independence. If action is to be taken either by the European Union through infringement procedures or by the Council of Europe through action plans, Venice Commission opinions, and other soft measures, how can we assess that the country is infringing the principles of the judicial independence? The questioner gives some pretty nice answers, but usually these answers are streamlined by the ministries of justice. And it gives us good information on the legal basis, not so much on the implementation. And I like to put you this on the scoreboard. We already know it, but it gives just an idea of how every country is scoring in terms of judicial independence. Pay attention, it's perceived independence of courts. So it's based only on the interviews carried out on citizens or targeted groups, how they feel the judicial independence is in their country. Is it respected? Is it scoring high or not? You see more or less the evolution is quite stable. It's quite stable because in the three columns you see the evolution 2016, 17, 18. And all again, Denmark, Finland, Austria, the Netherlands, scoring always very high. France is more or less in the middle. And Spain, it's my country of origin. And Portugal, it's rather at the very end. We could ask ourselves why. I'm sorry for the Italy, but it's also in the back of the perceived independence. This is the general perception. If this is the business perception on judicial independence. If you ask now a target group, the companies, again, Finland, Netherlands, UK is very much higher here. Luxembourg is high. Denmark is still in the top 10. And the rest is more or less very similar to the others. Interesting, finally, to see how the judges perceive themselves. And I'm sorry for you, but no comments on my side on this. But important in this table is that there is no huge difference. I mean, we can establish scores, but more or less none scores below 7. So all of them consider themselves very much independent, Danish kind of championships themselves. No? How useful are these scoreboards? Are they really significant, relevant, determined? And I tell you, assessing this is nothing but easy. Because these scoreboards are not only based on perception, but also based on CEPEJ data. And CEPEJ data are elaborated by the Council of Europe based mainly on quantitative data. So how efficient the system is, and how many judgments they render, how much delays they have, and so forth. No? So they are providing data on efficiency, quality, of course, and effectiveness, but not necessary on judicial independence. My question here is, can we really make a completely impartial evaluation of the compliance of judicial independence in one country, apart from looking at the law and saying, excuse me, this law is not complying with European standards. But beyond that, if the law is perfectly fine, how can we really go into implementation and practice in order to trigger measures, monitoring, or even infringement procedures within the European Union? And to that end, the most reliable approach might be the Venice Commission opinions. Why? Because it's their role to give advice, because it's their role to disseminate and consolidate these constitutional principles, and because mainly, it's an independent body made of constitutional law or international public law professors, and as far as I know, they make their opinions by themselves. Several data on the assessment, just for you to know, the main findings out of the report and the questionnaire, the assessment on compliance with the recommendation we undertook, the Council of Europe undertook on the judicial independence, we still find several countries, sorry, I'm not blaming, shaming, it's open public information in the report. When we go for the main recognition of judicial independence, which is the recommendation says, you have to set it out in your constitution. We could think that every constitution has provided for this. Again, even the most authoritarian ones. But we still find, not in Malta, not in Cyprus, not in Monaco, not in Luxembourg. And they are undergoing some reforms, I know, in Luxembourg. I know Malta has a lot of problems with that too, but not because it's not in the constitution, the judges are less independent or not. Ability to recourse to a judicial council or a remedy in case the judges consider themselves their independence threatened. Well, these recourses to protect the judicial independence is not in place in Switzerland. And you know, if you don't know, Swiss judges are elected. They have no tenure, they're usually very close to a political party, and their term of office closes or ends with the political term. And withdrawal of cases from a particular judge without valid reasons, that would be an interference of the judicial independence. Well, that there is the possibility in France, there is a possibility in Monaco. Of course, if it's a very tiny countries, there might not be a risk for the whole European Union, but still, it's not good examples. And here, what I was commenting before, commenting on judges' decisions. France, the criminal code sanctions the act of discrediting the judicial decisions with the aim of protecting the public image of the judiciary. It goes too far, no? Information of the French authorities, no, we have never prosecuted no one for this, okay? But it's always warning, flagging out, don't do it, it might be prosecuted. And no member state reports problems on the follow-up on paragraph 22. So no single state says, yes, that we have problems with judges, in the exercise of their adjudicating functions being disturbed or interfered. And no one reports, the states, on interference by superior courts, while at the same time, the reports carried out by the Consultative Council of the Judges of Europe showed that there is a huge problem of judges being interfered, disturbed in their independence by their superiors. But anyhow, pressures usually come in a very soft way. I'll leave it here so that you can have still time to put questions and enter the discussion. Just a very curious comment. We tend to think that the most, I would say, admired democracies, at least for some of us, which is the Scandinavian countries. We consider them very democratic, very equalitarian, and the judiciary is pretty much well perceived. You have seen the scoreboards, very perceived as very independent. And if we enter into analyzing the safeguards in place for protecting their independence, they are almost lacking. So we see that Norway has, in the disciplinary board's sanctioning of judges, many elements of the Ministry of Justice, and even members appointed by the government, and not a majority made by judges. And still, you ask the Norwegian judges, and they don't feel threatened by these disciplinary bodies. And selection promotion is a huge point. The tenure is problematic, I told you, in Andorra and Switzerland. And now the questions. Thank you for listening so attentively. Thanks. Shall I stay here?
Yes, please.
Okay.
Many thanks, Lorena, for this very stimulating presentation, which I think has really excellently paved the ground for the further debates today, and I'm sure will have triggered a lot of questions and comments. For example, I'm asking myself, why is it that in Latvia you consider yourselves the rate of independence as Latvian judges the lowest compared to the others? Are you just more realistic? Are you more self-critical? What is the reason for that? Yes, please. Sorry, yeah.
Labdien! Mans vārds.
Hello, my name is Jussi Lynch, and I am from the Zemgale Regional Court and have been... So do you have the translation? Can you hear? So my name again is Jussi Lynch, and I'm from the Zemgale Regional Court. It's an appellate court, and I've been working as a judge for more than 20 years, and at the same time I'm also the president of Latvian Association of Judges. Thank you very much indeed for a very interesting and thought-provoking presentation. Actually, all the issues that you raised are also being discussed by the Association of Judges virtually at every meeting. At every meeting, we talk about the independence of judges also from a fiscal perspective, if you will. And just recently, we had a very interesting discussion. Our courts do not have independent budgets. Only the Supreme Court has the right to independently decide what its budget is going to be. It is the Judicial Council which actually decides on the distribution of the budget allocations to the courts, and those budgets or those allocations are insufficient and, of course, do not promote the independence. And we think that these are important factors, or this is a way of indirectly influencing the courts by, withholding sort of the budget funding, and that affects, of course, the assistant judges who help the judges, in everyday work. We don't have enough assistants, for example, in Riga, where you have the biggest courts, because Riga is the capital. They don't have have enough assistants. Then also the staff turnover is a problem because a lot of assistants leave, and they join law firms where they get better pay and so on and so forth. So these are the factors that influence the independence of judges. That's why this perception here among judges is that we are less independent. So this is the answer to your question. On the other hand, starting from 2017, when this survey or study was made, we have made serious steps towards better or greater independence of judges, and I think that if you would measure it now, they would give you a better assessment of their or self-evaluation of their independence if you do it now. And I also have a question in terms of strengthening the judicial independence. We should probably also strengthen the independence of the judicial administration. Court administration, pardon me, because it is funded from the budget, and since it's funded from the budget, it has certain constraints in terms of resources, and probably it should be more independent, and also in terms of funding as well, and that would make sure that they have appropriate staff and appropriate resources to be fully independent.
Thank you very much for raising this question. You put the finger into the sore point because, of course, you know the problem. You all know the problem. We are experts who are working in strengthening judicial independence here and there. No, this is the weakest part, because despite the recommendation stating this is one of the standards, enough resources, states are obliged to provide enough resources for the judicial functions to be performed with dignity adequately. So payment, but not only payment to the judges, but as you say, the whole court administration, that the premises are showing a dignifying image, because if it's not linked to a certain degree of prestige and dignity, you won't attract the best lawyers, and you won't make them and keep them absolutely independent. Of course, this is a trend it's not by coincidence. It's absolutely a trend, I would say, worldwide, and specifically in Europe. Specifically in Europe to deprive them of prestige. How? To deprive them of social recognition. How? To get them into the lowest class in terms of economic wealth. So the younger students, the good ones, the best ones, say, why am I going to suffer in a court for such a low payment in such a messy, crappy, sorry for the expression, courtroom, if I can be very well recognized, very well paid, travel around the world, and, sorry, Suits has also done a lot of propaganda for young lawyers becoming very successful, except in Italy. When I was teaching Italian students, a majority said, no, we want power, and power is with the judges. So even if we're not paid that much. But still, of course, and there's no solution, because in pushing and putting pressure upon governments in saying, you have to provide resources. It's easy to say, not always easy to implement. You shall reform this legal provision, which is not in accordance with European standards. And then they change the law, or find the majorities in parliament to change the law. But when they tell the Commission, the Council of Europe, whoever, we are sorry, we don't have the budget, we don't have the resources, we cannot afford it. It's very difficult to say, yes, you can afford it, because you are deviating this money to other interests which are not so necessary. So this is a problem worldwide, court administration too. And I remember the worst case in the Bosnian Federation. Serbska courts, in the Serbska Republic, yes, in the Serbska Republic courts, they were paid directly by the Ministry of Justice, but in the Bosnian Federation, each court was paid directly through the mayor, through the municipality. And so allocating money or not allocating money to the municipality was rendering the judiciary absolutely inefficient in certain villages or towns or cities. My point here, not easy, you're always subservient from this, and it's you, through your associations, who really have to claim for your rights. Not saying we want more money, but it's the citizens that deserve higher standards of services, because this is a human right as established by the European standards. But otherwise, if you are not organized yourself like a trade union, judicial association, governments won't step forward and say, okay, you need more money, we're paying you. No. Sorry.
Well, in the end, it is always an issue of giving priority to certain state expenditure. And, but nevertheless, we do have now a judgment from the Court of Justice in that perspective, with the Associação dos Juízes Portugueses. And there's at least this definition of some minimum requirements, so decent salary is part of the job. Anyway, I wanted to add, with regard to the judicial or the court administrations, that I'm not so familiar whether your system here is similar to the Scandinavian system, but I know that in Sweden, for example, and also in Denmark, they have this concept of autonomous court administrations, which have a boss who is appointed for a certain number of years, has a lot of power indeed, but is acting independently from all the executive and so on and so on. And it seems to work very well. And what I want to say is, you always have to look at the whole picture. You have the legal situation, you have the structure which is set up there for the judiciary in the country, and then you have to test whether that is really working well in view of guaranteeing judicial independence. And I would say, as far as my experience with Swedish colleagues are concerned, they have a very high level, as the Finns have, even if they're only now transformed to that, and so on. And the trick of some of the new legislations or those defending new legislations in the countries you mentioned before is just picking one element of those different systems and say, oh, we're just doing the same as they do, but practice looks very different. Anyway, that was already too long. I think there was another request for the floor. No? No? We have time for one more question, certainly, or comment.
While they come up with another comment, just one comment. And with regard to the ECJ judgment on Associação dos Juízes, yes, they say decent salaries, but they don't define what is decent salaries. And decent, I mean, sometimes it's very indecent with regard to the role you are playing in society and the workload you have and the high responsibility you have. And the problem with court administration, at the end we may end up with blockchain solutions because they might be better regulated by algorithms rather than leaving it in personnel. But the discussion is always, we want a very professional manager, but the judge loses power in controlling the whole court functioning and administration, or so that he or she can concentrate in rendering judgments. But through the court management, you can really also influence so badly or so well into the running of the courts and the delay and the length and so forth. But I'm in favor of separate court administration as long as the rules are clear on how the budgetary issues are decided, because otherwise it's a source of corruption, booming corruption.
Okay, many thanks for that. Any further comments? No? Then we should break here for half an hour. We meet again at 1:15. Enjoy the coffee break, and thanks for your attention.
Thank you very much for this very kind introduction and also for the kind invitation. It's a pleasure to be here. It's my first time in Riga. So, dear colleagues, I should talk about the role of the judge in a modern society and how we, as academics, perceive the role of the judge and the rule of law. from the perspective and the survival, if I may say so, of European Union law. Now, the first challenge is always the technical challenge. So my starting point is that the rule of law is the bedrock principle of democracies. It has already been mentioned by Lorena that whenever law ends, tyranny starts, to cite from Locke. And it is thanks to the rule of law that states have governments of laws and not governments of men. Now, the rule of law is also a bedrock principle of European Union law. As the court held back in 1986 in Les Verts, the principle ensures that neither the European Union nor the member states are above the law. Now, this very concept is intrinsically linked to the concept of independent courts upholding the rule of law. In the EU legal order, a court always means an independent court, as Koen Leonards, the president of the court, formulated it. There is an unbreakable link between the rule of law and the principle of providing efficient judicial remedies, which only independent courts are capable of doing. So little wonder that the European Union reacts more forcefully with regard to violations of judicial independence than to other violations of the rule of law. This was the subject of the first ever rule of law framework that was conducted against Poland with regard to the independence of the Constitutional Tribunal in Poland. And this is also at the core of Article 7.1 proceedings going on currently against Poland, but is also mentioned in the Article 7.1 proceeding against Hungary. Now, there are also talks about strengthening the rule of law conditionality attached to EU funding, but also today, the common provisions regulations that guide the European and structural investment funds, they say that whenever there is a structural deficiency as to the effective functioning of the management and control system of an operational program, funds can be suspended. And according to the Commission's understanding, such an effective functioning is jeopardized if the losing parties, so to say, they cannot challenge the distribution of funds in front of independent courts. But I'm not here to talk about the various methods to enforce the rule of law and independence of the judiciary in the European Union, especially the ones that have a political flavor. But I'm here to talk about the role of courts and perhaps, if I have some time, the limits of judicial powers. And here I would focus on the specialty of the EU legal structure. In the EU legal structure, national courts, they do have a special role. They can set aside laws that are not compatible with EU law, even if these laws have a constitutional status. They may grant interim reliefs to ensure that EU laws are preserved before it's too late. Also, they might award compensation to individuals for breaches of EU law. And last but not least, there is the preliminary reference mechanism. And here again, if I may quote from the President of the Court, it is for the Court of Justice to say what EU law is, but it is for the national courts to apply that law to the cases before them. So they do have a heightened responsibility that is shared with the Court of Justice of the European Union to engage into a dialogue between the courts. And these different courts are the different hierarchies of courts, if you wish. They can only together ensure that first principles, such as direct effect, supremacy, or primacy of EU law, but also that Article 2 values, the rule of law, and fundamental rights are enforced. So it is little wonder that it is exactly this preliminary ruling proceeding that is being curbed currently by the regimes that they call themselves illiberal. And it's not visible on the slide. It's less important how many preliminary references are pending in front of the Court of Justice from Polish judges questioning their own independence. All I want to show to you is that judges are struggling in certain member states, and there is also a reference to a Hungarian case at the very bottom of the slide, where judges are essentially asking the Court of Justice to determine whether their removability, whether the disciplinary proceedings against them are indeed in line with European Union law or not. And the situation is quite severe indeed. As we talk, or yesterday, Polish judges and prosecutors talked about facing disciplinary and criminal procedures for upholding the rule of law and the EU law. They face disciplinary proceedings just because they turn to the Court of Justice in the form of preliminary references. And yesterday, a new leaked bill proposed that they be dismissed from office. And indeed, if I may go back for a minute to the preliminary references, I would like to share with you some facts that you are well aware of, but I just would like to recall that in the recent case law that comes up out of infringement procedures, the court made clear that whenever there is a violation of judicial independence in whatever way, Article 19 of the Treaty on the European Union is applicable. In the Portuguese Judges Association case that has already been referenced, the court had several avenues to make the case a European one. But here they said that the case has a European element because every member state's court can potentially apply and interpret EU law, and therefore it's an EU law matter whether they are independent or not. So automatically, Article 19 of the Treaty on the European Union on judicial independence is being triggered. So the court often does this. In a less controversial case, it states the principle, and then in a harder case, it applies it smoothly as if it was already case law for a long time. And this is indeed what happened with regard to the early retirement case of Supreme Court judges in Poland, where the court held that it was a violation of EU law that the retirement age was lowered from one day to another without any transitionary period. It's not impossible, it's not automatically contrary to the law to change the retirement age of judges, but there have to be compelling and legitimate grounds to make such a change to the law. These rules are subject to proportionality, and they must not raise reasonable doubt in the minds of individuals that the court is subject to external pressure. And all these requirements, according to the court, have not been met. And the problem is not remedied by the fact that the President of the Republic of Poland has the opportunity, the power to prolong the tenure of the judges for twice 3 years, because the President has fully discretionary powers. It's not bound by any binding guidelines as to what he should take into consideration. So there are no verifiable criteria, plus his decision is not subject to judicial review. So here we have a set of important infringement and preliminary reference cases that might be guiding for the future. But here let me talk a little bit about the limits that the court faces. Many claim that the Association of Portuguese Judges case and also the Polish case was a Marbury versus Madison moment for the court, where it was not entirely clear what the treaties say, but it had to step in order to protect the values that the European Union is based on. And this tension of what room of maneuver the court has is very apparent in mutual recognition cases that have already been referenced in the keynote speech as well. Now, interestingly, when it comes to mutual recognition in criminal matters, the principle of mutual recognition is inherited in the criminal law sector from the former first pillar, from the commercial law or business law sector, if you wish. However, whereas in the business law sector, we only had to mutually recognize that production rules are okay and goods can circulate if they have been produced in line with the production rules of one country. In the criminal justice sector, we don't have goods that circulate, we have judgments that have to be acknowledged by all courts. Now, interestingly, in the market sector, the principle of mutual recognition, it consummates, it extends freedoms, right? It's okay not to have as stringent rules of beer production as they have in Germany, in other member states, but also Czech beers should be able to be sold in other member states of the European Union. So it extends freedoms. However, in the criminal justice sector, mutual trust and mutual recognition, it curtails freedom because of the nature of criminal law, which automatically is about limitations of liberty, limitations of property, limitations of privacy rights, and so on and so forth. So therefore, in this slide, it should come as a surprise that in the market sector, there is a web of product liability rules and safety rules, technical specification and standards to create trust between the member states. But in the criminal justice sector, there is no rule to create this trust. The only safeguard is the existence of courts. Courts can highlight if in a member state a judgment has not been laid down in line with the principle of the rule of law by an independent judiciary in a fair trial. So the courts, all I try to say is that the courts, they too have a heightened responsibility when it comes to mutual trust and mutual recognition. And of course, the school book case is the European arrest warrant, as you will know, for the European concept of mutual trust and mutual recognition, which states that individuals must be surrendered to another member state for the sake of conducting criminal proceedings or serving custodial sentences. Now, the interesting part is in Article 1.3 of the framework decision, which says that it should not have the effect of modifying the obligation to respect fundamental rights and fundamental legal principles as enshrined in currently Article 2 of the Treaty on the European Union. So the question is what this sentence means. Is it the reason for mutual trust? We can trust another member state's judgment because we know that they are also bound by Article 2 values? Or is it an invitation to introduce a rule of law or fundamental rights exception in case we have some doubts as to the judicial independence of the issuing country? And according to the court's interpretation, now I mean the Court of Justice's interpretation, mutual trust means mutual trust. You have to recognize each other's judgment. This is what the court said in Opinion 213, vetoing EU accession to the ECHR. To be fair to the court, it also said that there might be some exceptional circumstances. But it didn't clarify what these exceptional circumstances are. And the clarification came in Aranyosi and Calderaro in the case about the prison conditions in Hungary and Romania, where some German judges had some doubts as to the prison conditions in these two countries and whether it would be okay to surrender individuals to these two countries, whereas they knowingly know that they would be exposed to prison conditions which, according to the European Court of Human Rights, amount to torture, inhuman and degrading treatment or punishment. Because before that case came out, the Strasbourg court held that prison conditions are so heinous, especially in Hungary, that a pilot judgment has to be rendered, which says that the overpopulation of 144% of Hungarian prisons means that essentially this is an Article 3 violation to send someone to prison in Hungary. And with regard to Romania, there were no pilot judgment, but there were also severe judgments. Now here the severe findings in ordinary Strasbourg judgments. Now, in this case, the court established a two-pronged test. It first said that the executing court has to check the general state of human rights in the issuing state, and it has to check how the individual suspect or convict would be affected. Now, the case was an easy one because an absolute right was at stake, prohibition of torture. It was an easy one because we had very persuasive evidence, pilot judgment from the European Court of Human Rights. You cannot get a harder evidence than that. But it was left open. What if it's not a pilot judgment? What if there is no Strasbourg court decision? What if it's just the Committee for the Prevention of Torture saying that prisons are not okay? What if it's just a national local NGO saying that there are some issues in the prisons? But also another issue that the court left open was, what happens if it's not a fundamental rights violation that is at stake, but one of the rule of law? And this is exactly what the famous case LM, or the Cermel case, is about. What if, can we surrender individuals to Poland from democratic countries where there is persuasive evidence, for example, in the form of an Article 7.1 proceeding against Poland, showing that courts are not anymore independent and suspects will not get a fair trial in Poland? And the court could have developed a new test for rule of law violations, departing from Aranyosi, but it didn't do so. It said it's the same test that we have to apply, because ultimately this is also a fundamental rights case. This is a case about judicial remedies, access to judicial remedies. So it's just another fundamental right. So first we have to check the general conditions of the courts in the country. And second, we have to check how the individual would be affected by it. How do we check the general conditions and how the individuals would be affected? According to the Court of Justice, the issuing and the executive court should engage in a dialogue, which means, for example, the Irish court, which had some doubts as to the independence of the Polish courts, has to ask the Polish judges, are you independent? You see the difficulties, and I would also say that it's not up to the individual to show how she or he would be affected directly. But once there is a fundamental and persuasive evidence showing that judges are not independent, there should be a shift in the burden of proof, and it should be the executing state to show how the individual would not be affected by this problem of judicial independence in the given country. I don't have much more time. Pardon? Not much more, so I will just skip this. Perhaps in the question time I will answer for the, I will have some time for the for the German case, all I want to share with you as some kind of conclusions is that the problem, I think, arises from the fact that the court's requirement mixes up, with all due respect, mixes up the responsibilities of the Commission, which is guardian of the treaties, the European Council, which can now suspend mutual trust if an Article 7 procedure comes to an end, and of individuals who do not possess an apparatus demonstrating risks to fundamental rights. So these cases demonstrate that ultimately, as in all incomplete constitutional systems, and the EU is an incomplete constitutional system. So in all incomplete constitutional systems, it's the courts which play a crucial role in carving out and applying rule of law and fundamental rights exceptions. But it's very difficult to come up with tests that, on the one hand, respect the loyal cooperation and the presumption of mutual trust vested in the protection offered by the issuing member states, and between the court acting as a constitutional or even as a human rights court. So I was supposed to talk about the academic proposals, and here is my academic proposal. What I proposed back in 2016 was a freezing mechanism. So I suggest that there is an annual scrutiny, an annual health check of all member states with regard to democracy, the rule of law, and fundamental rights. If a member state is fine with regard to these values, it should be in the green zone. It should be left alone, shouldn't be harassed. If a member state is in the yellow zone, there is a danger that it will slide down the slope of rule of law backsliding. Perhaps mutual trust should be suspended. And certainly, if it's in the red area, meaning that constitutional capture already happened. If this was realized, we wouldn't have to wait, especially for external actors. Now we are waiting for the European Court of Human Rights to tell us that things are not okay in the member states. We are waiting for the Venice Commission and other external players. We would not show hypocrisy towards the rest of the world. We like to show in the European Union that we are playing a pioneering role in upholding judicial independence and with regard to the rule of law. We want to export this principle to the outside world. This is a conditionality. This is an accession criteria. And if we cannot take care of it within the European Union, then it at least has a semblance of hypocrisy. And what people very rarely talk about, such an annual mechanism should show when trust can be re-established, when things are again in line with Article 2 of the Treaty on the European Union in the given member state. Now, I'm very proud to say it very rarely happens in the life of an academic, but this proposal has been taken up by the European Parliament in a resolution of 2016, and in a varied form, it was also taken over, at least the idea was taken over by the von der Leyen Commission. So if you have any questions, perhaps now or after the three talks, I'm very open, but also feel free, don't hesitate to write to me.
I have to say that it's very difficult to talk after the first two previous so great speech from academic view. And for a lawyer, it's much more difficult because, of course, we focus on specific cases, and it's sometimes difficult to have the very open view that academic perspective have. And anyway, first, thanks for inviting me, and it's really my deep pleasure, also because I'm the only lawyer here, so it's also my responsibility to be proud about lawyer. And as Wolfgang introduced me, I'm a lawyer, but I'm an Italian member of the management board of the fundamental rights agency, of European Union Fundamental Rights Agency, that is tasked with collecting. Yes, I'm not technological as well. Yes. That is tasked with collecting and analyzing data. Yeah. But the last. Collecting and analyzing data on human rights standards on European countries. And the method with which we work at the fundamental rights is concern surveys and also reports. And one of the last reports is the 2019 FRA report on the judiciary. Of course, I just signed the first words of this report, the beginning of the report, that underline the independence of judiciary is the condition sine qua non for the effective functioning of the common borderless area of justice based on mutual trust. And what the previous speech, the great previous speech underlined. And I'm not technological, so I had to review all my slides because during my flight they were canceled. I don't know why, but it's better because after what I listened before, I could review also my speech. And I want just to focus the 4 criteria that Lorena before underlined, the criteria focused by the European, the Strasbourg Court on the independence of the judiciary. And but before that, I would like also to recall that at the international level, the judicial independence was underlined by also by the drafters of the 1948 United Nations Declaration when they wanted to introduce the right to an independent tribunal. And also the special rapporteur of the United Nations Commission for Human Rights in 1995 specified that the judicial independence is a very important part of the law systems in all civilized countries. And for this reason, it must be enforced by constitution and states. So we are talking about European framework, but also the international framework, the judiciary. The judicial independence is a very important focus. And of course, also the target 16.3 of the Sustainable Development Goals expect United Nations member states to promote the rule of law at national and international levels, and also to ensure equal access to justice for all. That means the independence of a judicial branch is a foundational value for building a society founded upon the rule of law, as well as society shaped by constitutional democratic order that, as we already underlined, are based on the separation of powers. And it's worth noting that the main rule of law's components, namely legality, legal certainty, the prohibition of abuses, and the respect for human rights, are influenced mainly by the access to justice, in regard to which the judicial independence is a prerequisite. We can say that the judicial independence is a prerequisite of the rule of law system. But as I said before, I would like to because I change everything, I would like just to focus the four aspects for the Strasbourg Court that are very important to consider the judicial independence. As we said, the manner of appointment and the duration of term of office and the guarantees against all outside influence and also internal influence. That is a concept that the Strasbourg Court underlined in 2009 with the first turning point case. And of course, the appearance of independence, because it's not important also the independence, but it's also important how people recognize the judicial system. And all these criteria, and Loredana already said, all these criteria must be interpreted through two approaches, a subjective test and an objective test. It's very difficult to consider what is objective test. Also because, and I want to say immediately, the jurisprudence of the Strasbourg Court is quite criticized, especially from a Venice Commission, for not having a systematic approach. And so it's difficult also from lawyers to have a very good framework of the Strasbourg Court consideration on judicial independence. Of course, the subjective test should refer to the interest, personal interest of judges. And the objective test should refer to the doubts or suspicions of any undue intervention or influence from external powers, and whether the judge or the judicial system as well can give sufficient guarantees in order to exclude any doubts in this regard. Method of appointment. Of course, that's the first criteria. It refers to the manner of appointment, but it refers to the legal institution in charge of the appointment. We know that, generally talking, appointment of judges follows public competition, but what happens, and it could happen, if parliament or executive powers or judicial system itself are in charge of appointment judges. Article 6 of the European Convention requires independence of judges from the parliament and from the legislative powers and from the executive power as well. But the appointment of these last two powers cannot be seen to cast doubts or suspicious on the independence of the judge if they are free from pressure or influence from external powers when they are carrying out their duties. And it was underlined by the court in the Nien Hansen versus Denmark cases, where it was clarified that the court does not consider that the appointment of lay judges from parliament, this appointment alone gives legitimate doubts as to their independence and impartiality. It is not established that they were appointed with a view of adjudicating this particular case or had declared political affiliation concerning the subject matter and issues. And this aspect has been underlined in other cases. Of course, I just recall some cases, not all cases, but for example, Philippine versus St. Mary, the mere appointment by the legislator is not enough to declare the lack of independence of the judges. We must evaluate the court want to evaluate in concrete the situation. And in the cases Zahn versus Austria, the court specified that to establish the lack of independence, it is necessary to evaluate if the practice of appointment was unsatisfactory or it gave rise to risk of undue influence over the outcome of the case. This is the case. Zahn versus Austria. Second criteria, the duration of appointment. It's not specified a minimum of the term of the office. But the court had to face this aspect in several cases. And just talking about budget, it's very interesting, these cases, Campbell and Fell versus United Kingdom. Because the court had to face the short term of the office, but it specified that the term of office, when it's so short, is it's for understandable reason. The members are unpaid, and it might well prove difficult to find individuals willing and suitable to undertake the onerous and important task involved if the period were longer. So the question is, as we said before, also how much lawyers are paid. And I thank Lorena publicly because in Italy, law students prefer to become judges more than lawyers because lawyers are not well paid and judges are very well paid. But never mind, after Dr. Tappiner will reply me. And but it's interesting also to say that, in other cases where the court had to face the renewable 4 years appointment for a judge who was member of a national security court, the case is Inkal versus Turkey, the court said that the question was questionable. On the other hand, other aspects of this judge's status make it questionable. Lastly, their office as national, sorry for my mistake, but I had to make this slide just during the coffee break, as national security is only 4 years and it can be renewed. In this case, the renewable for 4 years appointment was questionable, but in another case, Maktub and Damjanovic versus Bosnia and Herzegovina, the court said that the term of office, the case was for a renewable 2 years term for an international judge who was a member of a court ruling on war crimes. And in this case, the court admitted that the term of office, yes, okay, it was relatively short, but this is understandable given the provisional nature of the international presence at the state court and the mechanism of international secondments. So, that's right, as Venice Commission said, the approach of the court is not so systematic, and for this reason, for example, for lawyers, it's very difficult sometimes to understand the criteria, the true criteria of the court. And, but the term of office is very linked to the third criteria. That is the guarantees against outside pressure, and specifically it's linked to the criteria of irrevocability of judges. And of course, the irrevocability of judges should be considered as a natural corollary of the independence of judges. But the absence of any provision by law in a law system, it cannot be seen as a proof of the lack of independence of a judiciary in a law system. And it was very clear, the court, to underline this concept, but I cannot go on. Yeah?
3 more minutes?
Just only 3? Okay. Yes. Campbell and Fell versus the United Kingdom. The lack of the recognition by law does not mean the lack of independence. But we have to see concretely, my goodness, technological, well, anyway, it doesn't matter. But we must see concretely, I will give the slide, I'm not technological, but we must see concretely the case. And in other cases, for example, Holding versus Ukraine, the Strasbourg court specified that the strong political pressure and permanent monitoring in the legal proceeding by the Ukrainian government was a violation of Article 6. And also we have to be very careful to the indirect pressure that could be happen by media, for example. And in the case of Kinski versus Czech Republic, the court stated that indirect pressure by other state actors could amount to the illegitimate intervention aimed at influencing judicial independence. Appearance of independence, very important aspect, because as I said before, and it was underlined by the court in the Inkal versus Turkey and Maurice versus France. It's important that justice must not only be done, but also be seen to done. And lastly, the internal, I would like just to say a few words about the internal independence. Internal independence from within the judiciary. Of course, it's a new concept for the court because just in 2009 it was recognized, and in a very important turning point case. In this case, if I can just, if I have the possibility to see, in this case, yes, Pavlo Klalic. Okay. Okay. Pavlo Kalicic versus Croatia. The court judged that internal judicial independence requires that they be free, the judges be free from directives or pressure from the fellow judges or those who have administrative responsibilities in the court, such as the president of the court or the president of a division in the court, as Lorena underlined before. So I think I have no time anymore. Thank you. I don't know. It's better if you match.
First in English, it's a pleasure to be here with the European Law Academy, and please be assured that in the slides that we saw in the beginning, it was a European law and not the European Judicial Academy. I hope the rest of the speakers will be able to follow me through the translation, but I may speak a bit fast, but I'm quite sure the interpreters will get the main message through. And so I'll switch into Latvian.
I will begin my speech by the following. We've heard a lot about institutional independence, but I will try to tell the way I see one very important aspect. And that's the difference between the Council of Europe regime and the EU law. I don't know all the details why in this panel we have emphasis on the EU law. I can tell you my very subjective view on this. And probably this is explained by a very simple fact which was already mentioned this morning. And that's the principle of mutual trust. This really makes EU regime different from the convention regime. In the convention regime, we have constitutional values, but member states have lots of discretion, and we always have individual verification. However, in the EU regime is much stricter. And this can be explained by a very, logical factor, because the EU has a common market, and the common market means common values. And common values mean, one element is the principle of mutual trust. Whether it functions, whether it really operates only in the area of criminal justice, I would say no. Please pay attention to this. Many of you have visited us already in our court. You've seen our court hearings, the grand hearings, as we sometimes call them. And quite often I hear the question, this affects judges of administrative courts because they work with individual decisions. But that's not the case really always. This morning we saw some very good examples, and I will refer to this. But now about the area of criminal justice. Of course, you might say that European arrest warrant is the most striking example. It's discussed most often. But are these the only examples, in view of the fact how often we now see cross-border elements in any legal proceedings, almost in any legal proceedings, contracts, protection of consumer rights, guardian, divorce, anything you could imagine. Anything might have an element of EU law, or at least cross-border element. Most probably these cases won't be mentioned, but I will give you some examples, perhaps that, for example, Schneerson and Campanella, and the case of Anderson, it was kidnapping a child to Australia, and Schneerson, that was taking or kidnapping a child from Italy to Latvia. Why we still speak about those cases? Why are they still relevant? Because this was the only case where we did not recognize the decision, the ruling by the Italian court to return the child to Italy. And the Strasbourg court, irrespectively of the government of Italy, said that this judgment could not be enforced. And then we have Avotiņš case, where again the claim was against Latvia, and that was a decision by court in Cyprus. And then the question was whether the Latvian court recognized this judgment in a valid way or not. These were Strasbourg court rulings. For many reasons. But these are very good examples that show why all these matters are very relevant. Well, that's what I wanted just to say at the very beginning as my initial consideration, that actually this element is part of our daily work. And now, if we look at the principle of judicial independence or the independence of a judge, the main element, of course, is institutional independence. Apart from the Portuguese case, there's another judgment by the EU, by the Court of Justice of the EU, which was pronounced on the 7th of January. That's the Spanish case. In both cases, the court recognized that the matter of judges' remuneration is very important for ensuring institutional independence of the court. However, in those specific cases, in view of the fact that different criteria were applied, especially in the Spanish case, this was only temporary decrease of salaries. So this was not recognized as a violation of judges' independence. With respect to Polish cases, the court's position is much stricter, especially with regard to the age of retirement. Because this is indeed, we saw that an institutional structure was put under pressure, and we saw that the executive power was intervening into the judicial power without any limits. But if we now look at my court, the general court, to which judges are appointed for a certain term, and now if we look what has happened now, at least 30% of the judges are new to the court, and some of the judges, their terms were not prolonged because of domestic situations in a couple of countries where governments were changed and the political majority changed. But has anyone, but can anyone say that our court has become now less independent? And I believe that the Polish context is very specific, and perhaps these matters are not relevant for Latvia. I hope so. But now I'll turn to some things that are more interesting to my mind. I would like to speak about two other elements, and perhaps other speakers will take up these as well. There are two other aspects to this matter. That's procedural independence and professional independence. And I reread last night and this morning some comments to the Constitution of Latvia written by Autrīte Briede and Professor Torgans, published this summer. And I would like to talk about these two aspects and what was also mentioned during the general plenary session of judges a couple of months ago. So the question is, how can a court make known to the public its authority? Of course, the institutional independence of the court, that's one thing. But the main tool of influence, these are the rulings made by the judges. And we have discussed a lot procedural economy, how far a judge is free in doing his or her work. Should the judge only follow the parties or just do what the parties demand from the judge? And I really like what our president, Mr. Levits, said, that perhaps we should study and we should research the procedural methods and the procedural weapons, so to say, that the judge has at his disposal and can use or not use when hearing a case. And I would say that the Court of the European Union, the judge is really a person in charge of the proceedings. We are not really hostage to the parties. But we also have such mixed competences. Sometimes, in some cases, we are officials in charge of the proceedings. Sometimes we are quasi-general court. But the question is whether the judge should examine all arguments, because the judge should hear the case not only in high quality, but also within reasonable term. It's always this sword of Damocles hanging above our heads. Should really a judge examine each and every argument presented by the parties? And should really the judge really have all the hearings that have been scheduled? I had only one case when the parties asked to reschedule the hearing, because that's something quite unacceptable, that the parties do not come for the hearing. It's really the respect that the parties show to the court.
And those who have come to our courtrooms, who've witnessed the hearings, they know that we are proactive and we give instructions to the parties to the case. And, you cannot come to the courtroom and expect the judges to give you instructions. You have to ask for them. We have our own deadlines, and to meet deadlines, I can give specific instructions about what I want to hear from the parties, not what they want to tell me, but exactly what I want to hear. And this is what we instruct them of and about. We before they take the floor, we tell them clearly what they need to focus on, and we give them floor during the hearing, and we give roughly 15 minutes for their statements during the hearings, and we basically manage the whole process. We moderate the hearing, so we decide when to give them the floor or not. And probably member states should refrain from very sort of strong intervention, but you shouldn't allow for the case to be delayed for 3 to 5 years. You shouldn't let the parties sort of determine how the case goes, or how the hearing, or rather the trial goes, because, you know, such delays would be unacceptable, rather, because they wouldn't make any sense at the end of the day. So procedural independence is something that Latvia in particular should focus in the next in the foreseeable future, and should carefully determine the sort of the mandate of the judge in terms of ensuring that a case is adjudicated in reasonable terms, while it is sort of still valid, if you will, because if the judgment comes 10 years too late, even if the judgment is of a good quality, it doesn't really help, you know, if you know what I mean. I mean, you get a fair trial. Nevertheless, such a delay does not ensure efficient legal protection if it comes too late. It isn't sufficient legal remedy, in fact, and I think I've provoked you enough, so I'll leave this sort of hanging or for the discussion. Another issue that I would like to address is intellectual independence, something that we have already talked about a lot in our comments to the Constitution, that judges should follow the law and should be governed only by law, should be restrained only by law, and I would like to make a premise here. On one hand, yes, judges are not, or are rather bound to a certain extent by the way that the case is presented by the parties, and we have to follow, of course, the law, the national framework, but we must also consult decisions of other countries because of the cross-border effect. And many of you have been in Strasbourg, and you know how this goes at the Strasbourg court, and it's quite a lengthy process. The average length of the proceedings is 6+ years in Strasbourg. In case of Latvia, it takes even more years or more time, rather not because of the Latvian government, but of the procedures of the Strasbourg court. Because, you know, where is this cross-border or transnational aspect important? Because, you know, any other member state court can challenge or parties can actually appeal against the decisions in the courts of other member states if they recognize, you know, if they see a case to be contended. And if we look at the Article 267 of the Treaty of the EU, this article is structured in a very peculiar, interesting way when it comes to the preliminary ruling process. So if a court decides that the preliminary ruling is necessary for the court to rule, it can refer the case to the European court. So basically, court of any instance may, it says it may refer the case or ask the preliminary ruling from the European court. But the next article says that if the ruling cannot be appealed against, then the court is obliged to refer the case or request preliminary ruling from the European Court. So there is no basically threshold, minimum threshold that says when you have to refer the case to the European Court, but there is an obligation or the maximum requirement there. So it has to go through all the appeal courts in order to understand whether that or come to a conclusion that there is no other interpretation possible based on the national framework. But there are also other aspects. I don't know whether you're aware of the Peteruchina case. I think this is a vivid example of what an effect a delay can cause. You know, by delaying an issue, eventually the court in Luxembourg said that we have, you know, we have actually delayed too long, and the decision to deprive the liberty has come too late. And then there are also issues that are related to admissibility of the cases. For example, if there are admissibility issues, and should this be postponed until the appeal procedures, or maybe the case should be referred to the European Court because Latvian legislation has gaps, and maybe it is even a case where the EU law applies because we don't have any national legislation. I'm looking at Wolfgang, you know, probably getting angry because I'm already out of time, maybe. But before he gets really angry and starts stopping me, I would like to mention two important aspects. So Commission against France is one of the cases that I would like to mention. For the first time in court's history, it referred to a violation of Article 207. It basically said that cassation or the appellate court of the France or cassation court of the France did not refer this case to the European Court. So this is a sort of a borderline, or a very ambiguous case. But in this case, court concluded that the EU law should have been applied. Whether we like it or not, we have to follow the judgment, and we don't have any leeway anymore. So this is about Article 267, which obliges the last instance court to refer the case to the European Court if it concerns the European law, because that is not an issue of the national courts. And two interesting cases that have become sort of a golden standard, but is on the verge of a sci-fi, because they have not yet been completed. And it has been mentioned at the beginning, the obligation or the duty to indemnify for any violations of the EU law. It was the Kobler case in which this obligation was mentioned. It was Kobler against Austria, but the criteria were not, their fact of violation wasn't proven, so indemnity was not requested. I will mention another case. It was C-16014, if I'm not mistaken, in which the courts indicated that the EU law has been violated and compensation is due, but we don't know yet whether the particular person or individual has gone to Portuguese courts to get compensated. Why this Portuguese case is important? The Silva case is important because the Luxembourg court mentioned that the case has already been decided on its merits at the national level, and if we now allow the applicant to request the compensation due to violation of EU law, this would contradict the res judicata principle. And, in fact, national legislation does not foresee a possibility to appeal against such decisions. And I really suggest you to read this judgment or ruling, because national procedural obstacles play no role here, because the court said that res judicata does not apply here. So the case cannot be reviewed on its merits. And if national legislation does not regulate this, then the EU law will apply automatically, and this is again another criteria. We sometimes say that we don't have the legal provision, or this legal provision does not apply, its scope does not go that far, and so on and so forth. But that cannot be used as an excuse not to rule on something, because there's always an EU law that regulates that. And of course judges are independent, work autonomously. However, the upskilling of judges must ensure that judges are not afraid when necessary to make this step further and decide on something that has never been decided before, because procedural rules will never be perfect. And I can share with you a case from my experience, the personal experience, quite an unprecedented case, but a very straightforward case. In fact, from the Latvian perspective, it was about the distribution or the assignment of the cases, and it turned out that this case assignment system basically assigned 2 cases to one chamber and the rest of similar cases to another chamber. And it turned out that our internal rules does not foresee the merging or compiling of such cases and sending them to one chamber, but there was a huge debate there, because we are actually bound by the same principles of the French court, juge légal. In other words, we cannot predict which chamber or which judge is going to be responsible for that case. But not all member states are bound by that. But we're an international court, and it took us 2 years to sort this out. But now we have full clarity there. But the thing is, we didn't have the procedural rule, and we had to be bold and do something that hasn't been done before. We had to basically fill this loophole in our rules of procedure or internal rules, and it took, there are quite heavy procedures for that, and it took some time. But nevertheless, we managed to sort this out. Seek and you shall find, and you should let the parties, speak, being fully aware that this is an unprecedented issue, and a miracle may happen. Parties may agree in the courtroom as well, no matter how sort of funny that may sound. What I'm saying, what I'm trying to convey to you is institutional independence as judges is extremely important, but you may call me naive, but our democracy is mature enough, Latvian democracy is mature enough to be free of political influences, content-wise, if you will. Of course, there are always doubts that we have to clear, and we need professional associations advocating for the rights and interests of judges. But as we sort of fight, we should have also a proper debate on procedural independence and professional independence, and should provide procedural means that enable the judges to rule in the best possible way and in a timely manner. So that's my contribution to our discussion. Thank you.
So thank you very much, Inga, and I think you have given. Thank you very much, Inga, and I think you have given many important messages here to the colleagues in Latvia, and I hope that will trigger many more comments and questions. And while I'm now inviting the panelists to take a seat here, I invite, first of all, you to take the floor because all of the panelists have exceeded their speaking time slightly, so there's perhaps not really an urgent need for them to respond to each other's presentations, but rather you should have the floor. Is there anyone who wants to make a comment or ask a question? Given the yes, please, again, you.
Oh, thank you. Again, I can say the following, that all these issues that the speakers mentioned or discussed, they are really on the agenda of Latvian Association of Judges. We are discussing these matters on a daily basis. Well, if you needed half a year at the European EU Court of Justice to deal with a procedural matter, for us that would take longer because we have all this legacy and also awareness of law in society and the whole legal culture that we have here. We encounter this daily. Therefore, we always be very cautious in comparing systems of different countries, Italy, Germany, and Spain, because the legal culture has evolved in different ways. But this does not mean that we could stop somewhere in our development or that we should not look at the best practice of other countries. What Ms. Reine was saying about interpretation of legal norms, this really could be the matter that really requires development. Judges and lawyers should not be afraid to interpret legal norms and interpret legal norms in accordance with their purpose and meaning. We shouldn't be waiting for some kind of legal amendments that would specify or regulate one small situation, but not the whole legal space. So this could be one problem. I could also say at the same time, while observing the processes that are ongoing in society, I believe that society is not that ready for very radical interpretation of legal norms, because society and also politicians expect the court to abide by the law that we have. So we are always going to have some clashes of interest. Did the judge have the right to interpret in this way? Even if the judge's idea has been very, very good, perhaps it has been premature if it deviates too much from the accepted interpretation of law. I believe that we see this problem not only in Latvia, but also in the other countries in legal context. That was my comment.
Yes, varbūt.
Perhaps I will respond to the comment. I think this relates, well, the previous speakers were saying that the influence by the media and by society, all this is also a matter of awareness and understanding. To what extent we accept media comments as influencing us. Media writes about Microsoft cases. They also write about major taxation cases, but we don't feel influenced by this. If a judge wants to feel that as being influenced, then the judge will do this. We had two members of the parliament who said this society doesn't know what they elect to the parliament. Well, we elect what we deserve. Perhaps society doesn't understand judges, but perhaps we should think about ways how to explain to the public, to society, and how we develop legal science, or how we develop legal training, how we also develop and improve legal publications. But that can never be the reason or cause for not passing judgments or for not adjudicating cases. I have a question to Ms. Reine.
Request to react on that?
No, just
No.
a few comments.
Very brief?
Very, very brief.
In a minute.
I totally agree with you, and I think that the basic problem on the gap between laws and practice, and the practice is up to judges and lawyers. That's the question. But I don't know if I can introduce now or after. It's important to talk about independence, but by people is also important from the perspective of community. It's also important to talk about impartiality of judges, judges without any prejudice. And independence and impartiality are together, are linked together. And sometimes the perception is that there is prejudice or judgments are not free, also for the personal interest of judge. So it's important also to give messages on impartiality of judges.
Thank you. I think this is an important point indeed, which has not been in the focus of the discussion so far. So please, you are.
My question goes to Mr. Eine. At the very beginning, you were speaking about the need to balance how detailed is examination of the case and effectiveness of the proceedings. So I believe that we also have to have some kind of limit or to the scope of verifying evidence. Perhaps you could give your opinion on the limits. Where do we find these limits or the border? For example, if we speak about Supreme Courts and when judgments are being revoked because all evidence had not been assessed, do you see any kind of limit or some kind of level that we should reach, where it's clear that indeed, because all evidence has not been verified, there are grounds to revoke the judgment by a lower instance, or just the very fact per se that some evidence in the case have not been verified? That could be the grounds for revoking the judgment of a lower instance court, or there should be some kind of additional aspect why this judgment should be revoked. I'll perhaps refer to one principle which we see in the case law of the Strasbourg and also court and also the Court of Justice of the EU, but that will not be a universal answer to your question. Verification of evidence, weighing of evidence, whenever it's taken up in some kind of context, usually this means that the right to defense has been violated. And in both courts have extensive case laws that the right to defense is very important. However, the fact that a piece of evidence was not assessed, this cannot be the grounds for revoking of the judgment of the previous instance unless this is one of the facts that could lead to another outcome of the court proceedings. And so when we hear cases and we look at the case and the evidence which could give us some kind of explanation, and the applicant should really explain to us how this particular evidence could have brought to another outcome. If I don't find this thread in my case, I say thank you, and that's it. And I usually am not examining this piece of evidence. Perhaps this is worth looking at. It's not a universal answer to your question, because indeed there are some elements which are linked to the right to defense, which a priori are very essential, and they must be complied with. I would say that we have rather few of such cases. I believe the majority of those cases are some kind of attempts made by the lawyers to throw into the application or to throw into the complaint reference to all possible evidence, and now you judges do it. Isn't it so? That's what we see, really. And the question is, why should the lawyer do this why should the judge do it if the lawyer has not explained why exactly this piece of evidence is so important?
Question of procedural principles and may vary between the different branches of the jurisdiction. But it's perhaps not really about the independence of the judiciary. I'm not so sure. More questions or comments? You've heard about this very important element of mutual trust for the working or the workability of the European judicial system, the area of justice, freedom, security, and justice, and that where that is missing, that the whole system might collapse. And you have heard about the cases, for example, the LM case, and there will be more cases with regard to Poland and also Hungary, which has been referred to also by Petra Bad, and Ms. Lehne has rightly highlighted the point that this is not just limited to criminal law, not just to the arrest warrant. Those are always the most spectacular cases. But it's, of course, very pertinent in the area of family law, of childcare, of, well, whatever is cross-border and consumer protection and so on, also cross-border labor contracts and so on. May I ask you, have you had any cases, for example, a European arrest warrant coming from Poland, where you were in doubt and thought that this is something to be considered according to the High Court judge in Dublin in her case? Yes, Seamus.
I was just going to add a little post. Sorry.
Go to the microphone.
Yes. I was just going to add a little postscript to the case that Petra spoke about, and it concerned a gentleman called Mr. Selmer, who was an alleged drugs trafficker who was a fugitive from justice in Ireland. And Poland made an application for a European arrest warrant to the Irish High Court, and Mr. Selmer's lawyers argued that he shouldn't be extradited to Poland because of the systemic breakdown in the rule of law in that jurisdiction. And the High Court judge, who was criticised greatly in the press in Poland, something I'll refer to in a different context later, raised this issue as to whether or not Mr. Selmer could get a fair trial in Poland. And she ultimately decided to refer the case to the ECJ. And they, I think essentially, and Inga will correct me if I'm wrong, they essentially came to the view that they couldn't give a general opinion. It would have to be applied to the facts of the particular case. And having endured all this criticism of the Irish High Court, it came back to the High Court. And having considered the facts of Mr. Selmer's case, the High Court decided that, in fact, he had not established that there would be a risk of an unfair trial and ordered his surrender to Poland. He appealed to the Irish Supreme Court, and the Supreme Court affirmed that decision. So ultimately, Mr. Selmer was, despite the misgivings of the High Court initially expressed, was returned to Poland, where I understand he now faces trial. Thanks.
Thanks. In fact, this Selmer case is identical with the LM case. It is sailing under different names. I don't know really why, but it is that one. Yes. Yes, Eileen Donnelly is the judge whom I know quite well, because she's also in charge of judicial training, or used to be, in Ireland. So yes, she made a landmark decision come forward.
Jā, tas patiesībā ir tas spriedums, uz ko atsaucās.
Yes, this is the judgment in the morning. That was LM case, where the EU Court of Justice said that indeed the Polish situation was special, but the court in the particular case should really see whether the applicant would really suffer from this unfair trial. And the Irish Supreme Court said that there would be no risk for this applicant. And as regards Aranyossi case, Aranyossi and Quadraro, these were the circumstances in the particular country, in places of detention for deprivation of liberty. And the German court is very punctual. The first judgment was that indeed you have to look at the situation in the particular country, perhaps if they are not meeting the requirements of Article 3. And then the German court asked the next question, identified which could be the prison where this person could end up in, and asked the second question, whether the European Court would see this particular prison as appropriate. So this question remains unanswered yet, but both in Aranyossi-Calderaro hypothesis and also LM is always the following. You can have, if you have doubts and suspicion, nevertheless, you have to look at the facts of the particular case.
Shows that perhaps in the context of prison conditions, it's a bit easier, nevertheless, to check. But if you ask the court, which has requested the arrest or issued the arrest warrant, whether it's really independent, well, I mean, there's a certain bias in the answer to be received. But before giving the floor to Petra, I wanted to come back to one comment which you made as well. You said that at the moment we always need to have external comments and external positions, such as from the Court of Human Rights. Would not accession to the ECHR, as it is mandatory under the treaties, have been a wonderful solution? And is not in this context, sorry for saying that, but the position of our Court of Justice a bit doubtful as well? If it had been on the line of the Advocate General, some adjustments, I personally think that would have been a much better way forward, because it would also have provided an additional tool in that context.
Thank you very much for all these wonderful comments and questions. I do think that that the scenario that you described, it actually results in a reverse discrimination. Reverse discrimination when people who are foreigners are better off than the locals, right? And this is very well known in EU law, and this is exactly what happens. So jokingly, I always tell my students in Hungary, whenever they commit a crime in Hungary, they should immediately leave and flee to a Western state, because then the executing court will negotiate for them decent prison conditions, which will not happen if they stay in Hungary. So this is one of the controversies, at least. The second controversy is what happens after, because we have wonderful window-dressed prisons with decent conditions, but what if the prisoner is transferred to another prison in 3 months, which happens in most of the cases? And if you check a report beyond surrender by Fair Trial Europe, then you will see that this is a problem on the ground in Hungary. What is another problem is the issue that you mentioned, Wolfgang, namely, would accession to the ECHR solve the problem? Partially yes, partially no. What I argue is that in the EU we could have higher standards than in the Council of Europe, which incorporates high contracting parties that have a rather poor human rights and rule of law record. What happened in Hungary after the Aranyossi case? Our justice minister managed to persuade the Committee of Ministers in Strasbourg that prison conditions in Hungary are now okay. How did he persuade him, the Committee of Ministers? We in Hungary introduced a new system according to which any prisoner who was placed into awful prisons can now automatically claim compensation. But in my view, it doesn't mean that the prison conditions got any better. It only means that the human rights violation happens and then they get some compensation, which can never undo the harm that happened to individual rights. But what is important from an EU perspective, the next case goes to the Court of Justice. Same question, can we surrender to Hungary individuals or not? And then the court says, well, we checked what the Strasbourg court says, and the Strasbourg court says now prison conditions are okay in Hungary, so we lift the Aranyossi jurisprudence, and now again prisoners can be sent back to Hungary to the awful prison conditions. So this is why I say that a sui generis European Union scrutiny could introduce higher levels of protection than the Council of Europe. And one final point on what is the consequence of all these cases. Well, I followed up the Telmer case up to the Supreme Court, and it was awful, really, what attacks Justice Donnelly got from the Polish side. You know, if you cannot challenge the criticism, challenge the critique, and there were really personal attacks against her. But ultimately, even though the Deputy Justice Minister in Poland said the Court of Justice in Luxembourg prevents us from prosecuting dangerous criminals like Mr. Artur Czermer. Isn't this a clear violation of the presumption of innocence? Yes, it is. But then when the Irish court asked the Polish court, so how do you interpret this statement by the deputy minister? The court said, well, we are independent from the executive, so it doesn't really affect us. So both Justice Donnelly and also the Supreme Court said, okay, so we surrender them. And I also followed up other cases like Pavel Lis in the United Kingdom, and also in the Netherlands there have been surrender cases. And simply this test that I described and that the court described in LM is not workable. So if you know of any cases where suspects have not been surrendered to illiberal countries on the basis of the LM test, just tell me, because I couldn't find any. And what is the consequence? The consequence is that democratic states, they return to original forms of extradition and they abandon EU law, they overwrite EU law. This is what happened in the Karlsruher Oberlandesgerichtshof, where a German court said, we will extradite to Poland if, first, we can check the prison, in case the person is sentenced to a prison sentence where he will be put. And second, if our ambassador can participate at the hearing during the criminal process. Now, this is not the framework decision on the European arrest warrant. This is a traditional diplomatic form of surrender. So the risks are very high. This is not just, suspending the European arrest warrant. This is suspending mutual trust and overwriting the primacy principle of EU law. And if this happens in criminal cases, it will sooner or later infiltrate also in business cases, because independent courts are not only important for the criminal justice to function, but also for a business, fruitful business climate to function. And I can't say too much about this, but because I was an expert witness in an international commercial arbitration case. But there, the commercial arbitration tribunal accepted that a foreign company cannot get an effective remedy against the Polish state in a business case. And therefore, it accepted the jurisdiction. It accepted the case. Now, if this, everything is confidential, I cannot say more about the case. But if this argument is taken over by an ordinary court, this is the end of the single market. So this is what is at stake here.
There might be other reactions from the Court of Justice to that, if that happens. And you're right, of course, if I'm not aware of this Oberlandesgericht Karlsruhe decision, but to do justice also to the Court of Justice, the rather reticent decision in view of LM, I think is also due to the fact that in the framework decision, and you had shown that recital, I think 10, it is clearly stated that member states are only allowed to deviate from the arrest warrant procedure if there is an Article 7 procedure in course and there is already the sanctions in place. That is what is stated in the recital.
Mutual trust can generally suspend it if this happens.
Yeah.
On an individual basis.
Exactly, but that has led, I was not there, of course, but that is my assumption, that has led the court to this individualistic approach, which is, of course, very cumbersome for the courts to handle. And my question to you, once again, is, have there been any cases here in Latvia of that type, where you at least hesitated whether or not you would send a suspect to Poland? No. No answer so far. No case so far. Then, Lorena, you had requested the floor as well.
Thank you very much for your excellent presentations and this ongoing debate. Also questioning again the mutual trust on European arrest warrant and the influence the judicial or lack of judicial independence in some countries might have. But my question goes back again in doing an analysis ex post, case by case, and every time someone is requested via an European arrest warrant or whatever another mutual recognition instrument, and then on the decision of the relevant executing court to just question, are we here again in an LM case or in another ones, and the approach of the German courts is already, okay, we are not referring again, we are surrendering, because otherwise we don't know what to do with all these detained persons here in Germany, no? And mutual trust should prevail. My question goes beyond. I mean, even following this case law, interesting case law on the European arrest warrant, and the absolutely contradiction that foreigners are treated much better than locals, and even worse, then we surrender from the European Union to third countries much more easily than within the European Union, which is absolutely incoherent on the system. What is the solution? We are asking, what is the solution? Undertake monitoring, general monitoring of each country, ex ante. So as the proposal for regulation on protecting the financial interest of the European Union and in the case of generalized deficiencies proposes. So every country is undergoing an examination on rule of law standards, including on judicial independence, and so getting scores. So we would avoid, by this preliminary assessment, any ex post preliminary references or refusals to execute mutual recognition instruments. And in such case, what do you think? This was my question, mainly to Petra. What do you think this proposal that a committee of experts would be undertaking this monitoring system, but not only on cases where the alert has been flagged out, but in general, every country in the European Union should undergo this examination by a group of experts whose independence, who knows what is its independence, which countries are to be targeted, populism of left or right wing, and on the other side, what would be the role of the Venice Commission in that situation if we create, my question is, you're proposing to create an internal and not relying on external assessments, an internal mechanism within the European Union, but how should it look like? Copy a Venice Commission within the European Union by this group of experts. I'm not sure this is the solution, and I'm not sure if this would increase the mutual trust or rather voice out who are the countries to be distrusted and then really introduce some problems for the whole solidarity within the European Union. I would like to know your opinion because I've been rethinking of this so much. Thank you.
Yes, in fact, I'm not proposing that because we were looking at me when you said it, but Petra proposed it. So.
Yes, indeed, there are many attempts to create a so-called Copenhagen Commission, as it was originally mentioned by Jan Werner Müller and others. Well, here is a problem. We do want to have some assessment of the member states. The proposal that I mentioned was originally coming from Sophie in 't Veld, a member of the European Parliament, who came up with this traffic light system. She wanted to have this rule of law index, a super rule of law index. We have many rule of law indices already. And I very much argued against it. And of course, I understand where she's coming from. She's a politician, and she says, if something cannot be measured, it cannot be fixed. Now, yes. Yes. Now, I'm very much against this getting scores. So that's why I like the traffic light system. The rule of law can be achieved in so many ways. There is no one-size-fits-all solution with regard to the rule of law. So if a member state is okay, leave them alone. Let's not discuss whether Belgium is more of a democracy than Luxembourg. Right? It leads nowhere. If, however, a member state is on the way to rule of law backsliding, it becomes an EU law matter because, on the one hand, this is the rotten apple in one basket problem, that it will just contaminate other member states as well, and because of mutual trust and other basic principles of EU law that will simply not function. So someone has to do the job. So far, the Commission very much wanted to do this job itself. But in recent times, and especially since the coming into force of the Juncker Commission, the Commission claimed itself to be political. Now, this politicization of the Commission didn't do good for the scrutiny of the rule of law, because immediately the entity will be seen as being biased. So you need, and there is the struggle. I'm very uncomfortable with this selection of people from various branches, former Constitutional Court justices and Venice Commission members and former judges and academics and whoever. But somehow you have to come up with a list of people whose independence is beyond doubt. And as I said, if the member state will not be able to question the criticism, it will question the critique and immediately say that they are being biased and being politicized. So somehow you have to get out of this conundrum. And I think it is an honest attempt on the side of the institutions to do this, even if you may criticize the constellation of this body that will do the annual scrutiny. Whether it will be a Venice Commission #2, and whether, there is no need to reinvent the wheel. We already have rule of law indices, we have CEPEJ, we have the Venice Commission, but I also argue for something with a European Union law flavor, because the Venice Commission is not going to take EU law principles, such as mutual trust, for example, into consideration, because it has another agenda. So you need an entity that will also look at these EU principles that are binding the member states and balance this somehow against Article 2 values.
I will allow just make a comment in English, because this is something that is fundamentally related to the Brussels bubble. But the Article 7 discussion has two major flaws. It didn't start from the right feet. Why? Because the European Union does not have conferred competences in fundamental rights. Problem number one. It doesn't, and it won't. And this is a key issue for member states. Any discussion on fundamental rights or on the rule of law touches upon something that is not within the competences of the European Union as a departure point. Second major flaw in this discussion is that majority member states don't see themselves being targeted by this discussion. They perceive this discussion as being something of pertinence only to 1, 2, maybe 3 member states. For as long as this is a departure point, the discussion is going nowhere. Either we have a common departure point, and then we may somehow find a common denominator in terms of EU competences, or this discussion will remain discriminatory. And I put the issue of situation in Poland and Hungary aside. It doesn't matter. These are not the only rule of law problems in the European Union. We have a major gender discrimination problem in the European Union, and I speak about Luxembourg, for example. That's it. And no one is interested in that. No one. No one is interested in lengthy court proceedings in Italy, which have been basically blocking Strasbourg court with cases. No one is discussing this as being part of the rule of law problem in the European Union. But everyone is discussing, I understand independence of judiciary in Poland is extremely important. But either this is something that concerns everyone or no one, and it has to be part of the EU competences.
Yes, this is also a very good point, that the rule of law has other aspects which are also of high importance and relevance for the functioning of the system, definitely. But nevertheless, what we have seen and just to quote Poland, nevertheless, again, the disciplinary chamber at the Supreme Court is an issue which I think is really outrageous. And there we have had this judgment as the last one in the row of the Court of Justice, which put the ball back into the camp of the Supreme Court. But the Supreme Court has now made its decision. And this decision, well, I mean, if you read it from the outside, you think that this risks to make the whole system explode, because it says that all the appointments of judges which have come under the new system are in fact not legal appointments. And if you combine that again and with the court in Strasbourg judgment on this Icelandic case, where they say even if the domestic courts think that this is okay, an appointment procedure was respected, but we think it is not. All the more, if the domestic court states that it is not in line with, then there is a need to, well, annul all the judgments which have been adopted with the involvement of judges. So the potential which this judgment has, I think, still needs to be explored. And we can certainly trust the ECJ to be even more clear, following now, or the expected judgment on the, sorry? Yes, exactly, which the Commission has put forward. So we expect that for next year, no? That will all be very, very interesting to follow, and it will affect all of us in our daily work in cases which are suitable. Any further last comment or question from your side? That's not the case. Then I would like to thank all the panelists for their contributions and invite them not only to lunch but also to continue to contribute to our discussion in the afternoon. But now lunch break is there, and I ask all of you to come back at 2 o'clock, please. Thank you very much.
Good afternoon. I will not provide you with a PowerPoint. I will just share with you some thoughts and views from the Netherlands, from the perspective of court management, but also from the perspective of the judge, him or her herself. The question was institutional guarantee or the individual one. Well, I think both have to be respected. And of course, you find both principles also in all international codes. I will touch upon a few topics which are relevant in the Netherlands and which result from the fact that, well, we in the Netherlands are considered to be a very efficient judiciary. But we have our pitfalls as well. And I want to touch upon certain topics with you. I will start with the internal independence. What is independence? What is independence? Well, I think at the core, it is the freedom of every judge to take the decision that he considers fair without undue pressure. And that pressure can come from outside the judiciary, but it can also come from inside. And one of the main reasons is efficiency. Let me state first that it's my opinion that a judge in a modern society has rights to independence, but he must also earn this independence, and that means that he also has some obligations. And those obligations are, in my opinion, twofold. He has to focus on society, he has to be responsive, he has to know what is happening, and he has to be efficient, and efficient means also a fair trial within a reasonable time. And that reasonable time, that is the motor of many measures that we took in the Netherlands. And don't let me be complacent, because we are not that speedy at all, but, well, we try to be efficient. And, well, you see that in different parts of the work. Maybe I should start with a little explanation of our court management system. All the courts in the Netherlands, we have 11 district courts. Amsterdam is my court. They're all similarly organized with a board, and the board is the president, the deputy president, it's me, and a non-judicial member, and we three are together responsible for the whole court. That means for financing, for housing, for ICT, for human resource management, of course for the administration of justice, for everything. And we together divide our tasks. President has more, strategic topics. In my portfolio is international cooperation and quality, and I think that's the best part. And my non-judicial colleague is always, bothering with the finance, who is obviously never enough, because I think one of the, main characteristics of our situation everywhere is scarcity of resources. So, besides this board, we have managers, judge managers, and they head the different teams in all areas of law. And in Amsterdam, we have 11. In total, our court is 1,000 people with 200 judges. So that's enough for Amsterdam. What do we do to make our work efficient? So we have 150,000 cases a year to process. Well, we have this extended situation of delegation. Delegation to judicial assistance. And there arises the first problem. I don't know if you have seen the latest opinion of the Consultative Council of Judges in Europe, number 22, and that states that using judicial assistance is, very efficient and it can enhance the quality, absolutely, but there is this risk. This risk to the independence of the judge, the risk that a decision is not fully and completely taken by the judge. The judge, so says the Consultative Council, has to familiarize with the case. And that means in all aspects. And that means establishing facts, writing the decision, every part of the decision. I will refer to certain remarks, because I think it is an important opinion. We have judicial assistants who prepare hearings, they write decisions, they do research, in fact they do everything, and then the judge comes at the hearing. And what this opinion says, if an assistant writes a memo or drafts a decision, you have the risk of anchoring that the judge beforehand has a sort of opinion, and he's not conscious about that one, about that opinion. And this is a good judicial assistant, and he delivers this note and this concept decision, and then the judge, as you all know, we have a lot of cases and we have a lot of decisions to take. And there you have that risk that you have an anchoring opinion, that you already think in a certain way. And if you then, and that's what the opinion says, also not draft the decision yourself, then you miss the chance to change your opinion. And I know it myself. We do many cases, and once in a while I say, let me write this opinion myself, this decision myself, and then I'm writing and writing, and I think, this is more, this is somewhat different from what I thought in the beginning. And that means that you really have to familiarize with the decision, which does not mean that you cannot use those assistants, because they're very helpful, but they can never replace the judge. And this is, I think, a pitfall from efficiency. What we have as another tool introduced in the Netherlands already 20 years ago, when I entered judiciary, this is about procedural independence. And this procedural independence is also very important. What was the situation? Well, as it comes to civil proceedings at the beginning, one judge gave a postponement for 2 months. Other judges accepted evidence, submitted 1 hour before the hearing, and it went all directions. And that was a threat for our power and authority. And people said, you don't listen to parties, you don't listen to society, we don't know what we can expect from you. And that's where we decided to draft guidelines on proceedings. And we developed them on all kinds of proceedings, administrative, criminal, civil, and also on all levels. So Supreme Court, Court of Appeal, and all district courts. And those guidelines, now everybody accepts them. But in the beginning, lawyers said, yeah, well, if we cannot get a postponement when we deliver our evidence too late, well, that's what we don't like. We want freedom, and this is our business model also. But we managed to stick to our guidelines. And that means that after a certain time, the lawyers do not ask anymore for postponements because they know that they won't get it, or they will get it in certain conditions, and always in force majeure. So these guidelines provided society and the parties a way of, this is how we as judges are handling proceedings here. This is what you can expect from us. And it improved predictability, and it improved uniformity, transparency. And it also strengthened our position as a judge, because we didn't have to argue and discuss every time again with judges, with parties, and with stakeholders, and with lawyers, because this was clear. This is how we do it here, and we think this promotes a fair trial in the sense of Article 6. You would say, is there a risk for independence? Well, that would be if the judge would have to stick to the guidelines in any case. And that is not how it is. Because if you want to deviate from those guidelines, you have to give a good reasoning, a good motivation, why in this case, on the basis of Article 6, it will be another decision than submitting the evidence or not submitting, accepting the evidence. So we think there is no violation of independence, and it helped us a lot to become a stronger judiciary. Another topic, the evaluation of performance. As court president or deputy court president, I have conducted many performance reviews, and I have underwent also many performance reviews. And well, what I think is a modern judge is part of an organization and is not working only for himself. And if you want to improve an organization, you have to do that together. Because a professional organization is something different from a collection or an organization of professionals. So that means that you, as a judge, have to take your role in the organization, because only together you can make it better. And that means that we focus on collective responsibility. We discuss together how the court runs, how the teams run. And in performance reviews, the contribution of the judge to his team is being discussed, as well as the quality of the work. And then we come at the, maybe the risk of independence. To what extent is it allowed for a court manager to take into account the substance of the decisions of the judge who is being assessed? Well, we have seen before that the Committee of Ministers and also the Consultative Council have set certain criteria for that. And that means that a judicial organization, the hierarchy, should never undermine an individual independence. But a system for the assessment of judges is allowed. And also is said in number 13, the opinion number 13, a court president should never put pressure on a judge to decide in a certain way. Well, we had in the Netherlands this discussion about the substance of the decisions. And we think in order to improve the quality, it's necessary that somebody else reads those decisions. But who and how? Your colleagues, your president, your head of department, well, a court of appeal, a commission. We did not manage, I have to say, in the Netherlands to set up a system that addresses this need, and I think it is a need. Judges show very much resistance to having discussed their decisions by anyone else after issuing them, and they state that this would be a violation of their independence. What we did, and what we do, in fact, already many years, but what we have extended is the practice of intervision. And that means before the decisions are pronounced, before they are issued, co-lecture takes place. And that means within your team, other judges, one other judge normally, reads your decision and can give his feedback, his opinion, his comment before issuing. He's not imposing anything, but he's saying, well, is this analysis, is that good? And have you thought about this? And when I read it without seeing the complete file, I think, is this a coherent story? Well, this is a way of, in fact, quality improvement, but it also addresses the, concern of not all judges, but of many judges that reading decisions after they have been issued is a violation of their independence, and especially when it is your court president or it's your head of department. Okay, bye-bye. And what does the Consultative Council, in its opinion number 17, say about this? Well, the boundaries are that the legal merits of a case, they should not be assessed by your court manager. There we have appeal for that. But you can concentrate, and you have to concentrate if you assess those decisions, on the methodology a judge applies. So it is the judgment comprehensible, the correct usage of the language, analysis, reproduction of the facts also. Oh, well, this is the gray area, I think the gray zone. But the merits and the weighing of and the balancing of interests of parties, that is up to the judge, I think, and exclusively up to that judge. We have another internal mechanism to improve efficiency. Well, on one hand, maybe myself, I'm one. We often tend to postpone a hearing for reasons of lack of time. And in fact, that is, or workload, or reasons of comfort, let's be clear. We're all human beings. But since we cannot if we do that, we cannot use that space good enough. We cannot easily fill it up with another case. And that means that you lose time and that you lose efficiency. So what we do in several heads of several departments, the head of a department, normally a senior judge, decides on all requests of postponements. And the instruction is, in the beginning, you don't allow it because it's not efficient. And the question is, when do you here come in the space of the judicial domain of the judge? Because the judge himself could have a good reasoning for postponements as it comes to the content of the case. Maybe it's a witness that he really wants to hear, and he thinks this is necessary for the case. So this is also a mechanism that, you should be aware how you use it and that you leave enough space for the judge. Well, we suffer, although in the Netherlands the idea is always that we have lots of money, no, that we have also scarcity of resources, and that means that we also suffer financial pressure. And that means that, it's always a challenge to find a balance, as it comes to hearing witnesses. This party wants to hear 50, then I'm 3 months ahead. How many real witnesses do I need for my decision? And that requires, of course, good preparation of the case. But also this balance between efficiency and, quality, so you want. And judges in the Netherlands have felt long time the feeling that they should really diminish not only the postponements, but also the number of hearings for witnesses, because our system in the Netherlands is so that every case that you decide gives you money, gives us money. So then there is this pressure to decide more cases, and you need more time, and not so many witnesses. So we have to keep an eye on the efficiency and at the quality at the same time. Maybe a last, well, no, I have 2 points. I hope I have time. I have, in fact, no idea how much time I have left. Couple of minutes. Okay, then now we'll try to be a bit swift. I would like to address also with you the question of how far can you go as judiciary, as board in my case, but maybe also for you, to define the priority of handle a certain type of cases. In fact, we do that all the time. We give priority to maybe refugee cases that come in, or other small claims of insurance companies that are coming in. How are we dividing our time, and what cases do we give priority? You can ask yourself, is that our task? Well, we in fact think that's our task, but we have lots of discussions between judges and their court presidents. What is really the most urgent case to decide at this moment? Type of cases, because it's always type of cases in our country. So we have to assess the need of society, and we have to be careful when it comes to cases for which we are compensated financially. And sometimes we get more finance for handling refugee cases within 4 weeks. Then we get lots of money. But you have to ask yourself, the tendency is, yes, okay, we do it and we have a lot of money and we can hire our judicial assistants. But you have to ask yourself, am I now here fulfilling a desire of the government? Or is it because we as judges, and then what is our criterion? Why do we want to give priority to that case or that? Well, then I think I'm going to end. I think this is the reason why we as judges should always join. Not only to be stronger towards media, towards government, but because we have to create our own judicial culture and community. And then you are strong. And that is what you have to do. And you can only do that together. And that is defining your norms and your values. And by performing and together, it is, in my opinion, that it's more difficult to break up a judiciary. And structures and systems in itself can never do that. The aim should always be to invest in the judiciary, in each other. Thank you.
Good afternoon, everybody. I'll try and be not too long because I'm afraid you have to listen to me again later in the day. So I hope to stick to the time limit, but I'm sure you'll tell me if I'm going over. So for those of you who don't speak Irish, my name is Seamus Noonan, and I'm a judge in the Court of Appeal in Ireland. It's a collegiate court, and some of the things that Esther said actually struck me very much when she was talking about anchoring opinions and how you can be very influenced by other people's views of having written something before you do. Sometimes when you have a blank sheet of paper, things turn out differently than when you're presented with the formula. Well, I'd like to say firstly thank you to Wolfgang and our Latvian hosts for having us along to this event, which I have to say the hospitality and so forth has been excellent. It's my first time in Riga. What a beautiful city. I'm very jealous, and it's a great pleasure to be here. I just want to say a few brief remarks about the Irish system, because obviously I'm looking at it from a particular perspective. Our system in Ireland is based on the English common law system, which is not surprising considering that England occupied Ireland for 800 years. And in fact, I was particularly pleased when Lorena pointed to the fact that on the EU Justice scoreboard we came 3 places ahead of the UK. So obviously 800 years can be wiped out very quickly, as the results of the election today tend to suggest. But in any event, we are where we are. But the system of justice that operates in Ireland, as I say, is a common law system based on the English system, but with one important difference. We have a written constitution, whereas the United Kingdom does not. And up to relatively recently, as you may or may not know, that has not given rise to any difficulties, but there was a recent case involving the proroguing of Parliament by Mr. Johnson, the newly elected Prime Minister, which came before the English Supreme Court, the UK Supreme Court. And I think the absence of a written constitution and the unwritten conventions that have obtained in the UK for many years, the flaws in that system were, I think, evident in that case. One of the features of a common law system, as you probably know, is that it's an adversarial system. It's not an inquisitorial system. And this has some positive aspects, but some negative ones too. And I think it's fair to say that one of the negatives in our system is that civil litigation, at any rate, is party-led litigation. And one of the unfortunate consequences that can arise from that is that there can be lengthy delays in proceedings where they are not case managed by the court. And Inga touched on the difficulties that can arise where there are lengthy delays in hearings of cases. And as they say, the old adage, I think justice delayed is justice denied is very relevant in that context. One of the difficulties we have encountered in Ireland certainly is from the point of view of more case management, where certainly in recent years that has tended to be more of a trend. But the downside of more case management by judges is that it implies more costs for the parties to the litigation, and costs in Ireland is another problem that we have, because the cost of litigation in Ireland is extremely high, and in fact has got to a level now where we are seriously considering whether or not that in fact is an impediment on access to justice, but that is another day's work, as they say. Another difficulty I think we face in Ireland, I'm not sure how many judges there are in Latvia, but we have a relatively small number. We have a population of about 5 million people, but we have only 160 judges in the whole country. And our 5-tier system starts with the lowest court, which is the district court, and then above that the circuit court. And then the High Court is the court that has full originating jurisdiction, and we have 40 High Court judges. So as you can imagine, that places a great strain on the judicial system in terms of trying to deal with the vast backlog. I was absolutely gobsmacked to hear Esther say they deal with 150,000 cases every year. We can only dream of such things in our jurisdiction. I just want to touch briefly on two aspects of, I suppose, independence of the judiciary insofar as personal experience goes. I suppose the first thing to say is that our written constitution guarantees judicial independence. It is expressly written in, and in fact two aspects of that I think are currently relevant, certainly in Ireland. The first is one that's certainly dear to my heart and that of all my colleagues' heart: judicial remuneration, which is a difficult subject, and in fact was the subject matter of a lot of public controversy not long after the economic collapse in 2008, because with the introduction of austerity, the government proposed reducing pay and remuneration for everybody right across the public service. And of course that included judges. But the problem for the government was that Article 35 of our Constitution provides that judicial remuneration cannot be reduced during the currency and office of the particular judge concerned. And that created a problem, which I have to say, in fairness, the judiciary themselves did recognise, because although I wasn't a judge myself at the time, it was very much in the headlines. And the vast majority of the judiciary proposed getting around this by accepting voluntary pay cuts in line with what had been proposed for other members of the public service. But unfortunately, in order for that to pass muster, it had to be effectively unanimously adopted. And of course, trying to get unanimous agreement to anything in any group of people, particularly judges, is a difficult matter. So it wasn't possible to agree that, and consequently the government faced the dilemma that they couldn't reduce our pay without without changing the constitution, which they duly proceeded to do. And the matter became quite heated in the course of public debate about it. And ultimately, as I say, there was a referendum which proposed to introduce an amending provision into the Constitution to provide for a reduction where appropriate in judges' salaries, and it was overwhelmingly passed by the public. And I have to say that it was a matter of great regret to the judiciary that it had turned out as it had, because in PR terms it was a total disaster. However, as I say, that goes back quite a few years, and hopefully with the passage of time it has faded from the public memory to a significant extent. Regarding the, and sorry, just before I leave that topic, I should refer to the case that was mentioned earlier on today, because this has been directly considered, as you know, by the ECJ in the case involving the Portuguese Court of Auditors. And as you know, that was a similar situation where the Portuguese authorities were proposing to reduce the pay of judges in all courts, but particularly in the Court of Auditors, who brought a case claiming that this was effectively undermining their independence and thus contrary to European law. And the conclusion of the European Court, and I'll just quote it briefly, referring to the measures to reduce the salaries was as follows: "Those measures cannot therefore be perceived as being specifically adopted in respect of the members of the Court of Auditors. They are, on the contrary, in the nature of general measures, seeking a contribution from all members of the nation's public administration to the austerity effort dictated by the mandatory requirements for reducing the Portuguese state's excessive budget deficit. In those circumstances, the salary reduction measures at issue in the main proceedings cannot be considered to impair the independence of the members of the Court of Auditors." So, sadly for the judges of the Court of Auditors, they had to take the pay cut like everybody else. The other aspect of judicial independence, I suppose, that I can speak to from personal experience is currently very controversial in Ireland, and it relates to the appointment of judges and how they are appointed. And here again, our constitution provides that that judges must be appointed by the government, which one might have thought may give rise to problems, but for the last 100 years or so it has not, for whatever reason. Certainly until recently, most appointments to the superior courts in Ireland have come from the ranks of barristers, and I used to be a practicing barrister before I became a High Court judge about 6 years ago. And but it's a relatively small group of people, a few hundred people, and generally speaking, the Attorney General is the liaison between the judiciary and the government, and the attorney of the day will perhaps suggest certain people under the older system at any rate. And of course there was a nod and a wink that people who were appropriate and suitable got appointed, and by and large it didn't give rise to any problems. More recently we have a body called the Judicial Appointments Advisory Board, which is composed mainly, well in fact entirely of lawyers, but mainly of judges. And here again they recommend people for appointment to the courts, and the government generally will accept those recommendations, although as a matter of law they are not bound to do so. But the recent controversy arises by virtue of the fact that we currently in Ireland have a minority government supported by a number of independent members of Parliament, one of whom is a minister and feels that the system that has obtained up to now smacks of cronyism, as he has described it, and he is proposing to introduce a new system of appointing judges where the body that will be responsible for the appointments will have a majority of lay persons on it. This is something that we in the judiciary have strongly resisted. We feel it is a threat to our independence, particularly in circumstances where people have been invited to seek membership of this body, and the obvious types of people that one would expect to see on such bodies are representative of interest groups of one sort or another. And it certainly seems to me, and I think most other judges in Ireland, that they are exactly the sort of people that should not be appointing judges, because naturally enough, most groups who have an interest want to appoint people that have the same point of view, and in my view, at any rate, that's not something that is appropriate for consideration in the appointment of any judge, certainly in our jurisdiction. Just briefly, I want to say something about the role of court presidents, because again, Esther has touched on this, and our system, in fact, is quite different. Each of our courts has a president, but the president's function is not in any sense to impinge on the individual judge's right to decide cases in whatever way he or she thinks fit. The president is more of an administrator who assigns judges to particular branches of the court, so you could be assigned to criminal cases or family cases or administrative cases, and that's a matter for the president of the individual court, and also for the president to determine the way cases are generally distributed, although each division has its head, and until recently, when I became an appeal court judge, I was the head of the division that deals with administrative judicial review law and cases of that nature. So it was my function to assign cases among the judges who are designated for hearing those kind of cases. But it was no part of my function, and similarly with the president of the High Court or the president of any of the other courts, to offer a view as to any particular judge's performance or indeed the manner in which decisions or judgments are given. In that regard, certainly in Ireland, each judge is effectively an independent republic who can only decide cases as he or she considers appropriate, and we don't regard it as appropriate that other judges should interfere in that. I do, however, recognise what Esther says. Performance evaluation is never a bad thing in any circumstance, and I often felt that it might be helpful, for example, when I was managing the judicial review list, that we'd have a yellow, orange and a red button at the back of the court you could press, depending on your experience, like when you're leaving the airport. That was the closest we got, I'm afraid, to independent evaluation. However, I must say that being on a collegiate court now, it's quite different. There is I sit on a court of 3 judges, and generally speaking, one of the judges is either before or immediately after the case effectively appointed as the lead judge to write the judgment. And that's not to say that the other judges are not free to write judgments also if they wish, but it is, I think, comforting, at least when compared with my experience as a single judge in the High Court. It is comforting to have other judges to correct your homework, as it were, and offer suggestions as to how things might be improved. And of course, if they don't agree with your view, they're perfectly entitled to write a dissenting judgment if they wish to do so. So that's all I propose to say for the moment, and as I say, you'll have to listen to me again later, so I'll leave it there. Thank you very much.
So, first of all, I have to thank the Latvian court administration and ERA for the invitation to this interesting conference here in Riga. I arrived yesterday morning, so I had the opportunity to spend the day as tourist in Riga. It's really a wonderful place. I'm a judge coming from the court of Bolzano. Bolzano is as mentioned, a town in the north of Italy. Our province is an autonomous province, a multilingual province. That means that 3 languages are spoken mainly, Italian, German and Latin. This explains also my name. Stefan Tapana does not sound really very Italian. Indeed, my family has Austrian, German roots, and my mother tongue is German. I'm belonging to the German-speaking population of this province. We have about 530,000 inhabitants. Bolzano as a town has about 120,000 inhabitants. Our court has the jurisdiction about this province, about 530,000 inhabitants. That's my courthouse. I'm dealing with criminal cases. I'm a criminal judge. I'm preceding a panel of 3 judges. I'm a criminal judge. It's very Italian, yes. It was built by Benito Mussolini. It's a typical Mussolini-style building. It's the same architect that built the buildings, court buildings in Milan, in Palermo. Always the same buildings, but we use them still. Well, our question today is judicial independence, an individual or a collective guarantee. It was very interesting for me to learn this morning during the speech of Lorena that Italian judges consider themselves very independent, but that the population, unfortunately, doesn't perceive it in the same way, doesn't see it in the same way. It's a very important argument for the Italian judiciary independence, because in Italy we had for long years a prime minister who had serious troubles with justice, who had to stand several trials, who was condemned for tax fraud. The same prime minister was and is still the owner of the major newspapers and the major private television, so you can understand that for us in Italy it's a big argument. I will take off my watch to respect the 50 minutes. Okay. The independence, judicial independence as a collective guarantee is assured by our constitution. The Italian constitution came into force in 1948, the 1st January. That means 2 years and a half after the end of the Second World War, and 2 years, 2.5 years after the end of the fascist dictatorship. Italy had more than 20 years of fascist governments and obviously of a judiciary under the control of the fascist government. So the Italian lawmaker, the Italian Constituent Assembly tried to assure this independence of the judges, of the judiciary in the constitution. We have, for instance, Article 101 that states justice is administered in the name of the people. Judges are subject only to the law. Very important principle, judges are subject only to the law. Article 104, the judiciary is an autonomous branch independent of all other powers of the state, quindi complete separation of the powers of the state. The same article, 104, speaks then about the High Council of the judiciary, the High Council that grants our independence from the other powers of the state. The High Council is presided over by the President of the Republic. We have 2 members ex officio, by right, the first President and the General Prosecutor of the Court of Cassation. 2/3 of the other members, 16, are elected by all the ordinary judges. 1/3, 8, are elected by the parliament, by the 2 chambers of the parliament. So we have 27 members. The term of office is 4 years. 3 members ex officio, 16 members elected by the judges. From these 16 members, 10 are judges, 4 are prosecutors, and 2 are judges of the Supreme Court, of the Court of Cassation, and 8 are elected by the chambers. The CSM, Consiglio Superiore della Magistratura, the High Council, guarantees the autonomy and independence of the ordinary magistrates, not of the administrative judges. They have their own administration. They are not in Italy a part of the ordinary jurisdiction, the administrative judges. The High Council adopts all the provisions affecting the status of magistrates, recruitment, assignment, transfer procedures, promotions, dismissal from service, and so on. And also for disciplinary actions, the GSM is competent. very important also, the Superior Council of the Judiciary is presided over by the President of the Republic, so by the highest office of the Italian Republic, together with the President of the Supreme Court, Corte di Cassazione, and the Prosecutor General of the Supreme Court. Article 105 of the Constitution states that the High Council of the Judiciary, in accordance with the regulations of the judiciary, has jurisdiction for employment, assignments, transfers, promotions, and disciplinary measures of judges. So all the important decisions in the life of a judge are taken by the High Council of the Judiciary, not by the minister, not by a court president, by the High Council. And to remember, two-thirds of the members are elected by the judges and prosecutors. Also important, Article 107, judges may not be removed from their office, not be dismissed or suspended from their office, or assigned, transferred to other courts or functions, unless by a decision of the High Council of the Judiciary. And all these decisions have to be taken in any case with the guarantees of defense. Another very important article, another important statement in the Constitution, judges are distinguished only by their different functions. That's a very important statement for us, for the Italian judges, and I will explain it a bit better now. On the one hand, as we said, the High Council of the Judiciary assures also the individual independence of judges and prosecutors. Access to the profession of judge or prosecutor takes place only through a public competition. I don't know if you know this an old Italian film. It's called Un giorno in pretura. It's a film from the 50s. Translated, it could be One Day in a District Court. Very funny film, I think from the 50s, 55 or something like this, about one day in a district court, in a small court. You see also Alberto Sordi and other famous Italian actors in this film. As we said, all decisions regarding the career of a judge are taken by the High Council of the Judiciary. Very important, but I think it's quite a unique system in Italy that we have a complete separation between grade and function. I will try to explain it a bit better. That means mainly that a judge and a prosecutor goes on with his or her career mainly on the basis of seniority and on the basis of periodical assessments, independent of the functions that he or she has in the judiciary. To make an example, I'm working as a presiding judge in the first instance, in the court of first instance. I'm presiding a panel, but I have the grade and the rank of a Supreme Court judge, and also the salary of a Supreme Court judge. That means your salary and your grade increases with seniority if you get always positive assessments, positive evaluations. Every 4 years, we have evaluations, assessments. It's quite a complicated mechanism. It starts with an assessment of your court president and goes on until the final assessment by the High Council of the Judiciary, the High Council who is taking all the important decisions. If the evaluation, if the assessment is positive, you go on in your career and you go on with your salary, independent of the functions. As I explained during the break a few months ago, I was thinking about applying for a job at the Consiglio di Stato. That's the Supreme Administrative Court of Italy in Rome. I started to write the application papers. Then I looked at the salary and I learned that my salary would decrease. I would earn less than I earn now in my court of first instance, because I have the rank, the grade of a Supreme Court judge of second level. In the states, in the Consiglio di Stato, I would start as a Supreme Court judge of first level. So I didn't apply anymore. But I think that's quite a unique system, and for us it's very important to guarantee our independence, because a judge in Italy, when he or she has to decide a case, has never to think about what would be the best decision for my career, what would be the best decision to go to get a job at the Court of Appeal or at the Supreme Court. I can think about what's the right decision, because my career goes on with the evaluations and the assessments, not with the functions that I get. As I said, every 4 years we have the evaluations for the first 28 years. So we have 7 levels. 7 per 4 is 28. After 28 years of service, you are so perfect that you don't need any assessment, any evaluation anymore. Another particular Italian system, our court presidents are appointed only for a term of 4 and eventually another 4 years. So the court president is primus inter pares, first, to say it in Latin, the first among equals. After 8 years, a court president becomes a normal judge again. He or she could apply for another job as a court president in another court, but otherwise we have a lot of colleagues in our court that after 8 years, they are working now as normal judges, and we have another court president. So it's quite a democratic system. And court presidents get paid no extra salary for their function. So for those 8 years, they don't get salary. A few words about court management, case management, quality control, and the role of presidents. Our main problem in Italy, when we speak about case management, is the length of trial. It was mentioned this morning. Italy is the dark red. Latvia is here. So maybe next time you should come to Italy to teach something to us. Now, no other state has been condemned so often by the Court of Strasbourg, by the European Court of Human Rights for the violation of human rights because of the length of trials. This is the statistic from 1959 to 2015. Very sad, very sad. But we have a commission, the 7th commission of the High Council, who should monitoring the workload of the single judges, the length of the proceedings, the duration of the judicial decisions, and so on. We have also a law decree entered in that came to force in 2011, but only for civil, administrative, and tax proceedings, not for criminal cases, fortunately. So, for the civil proceedings or administrative and tax proceedings, the court president should organize, after consulting with the president of the local district bar association, a program for the management of civil, administrative, and tax proceedings. Obviously, with the target to reduce the duration of the proceedings. Our main aim is now to finish all the proceedings that last more than 3 years. That means 3 years is a kind of deadline. No judge should have proceedings during more than 3 years, also in criminal cases. Every 6 months, we receive a kind of statistic from our court administration, and obviously the proceedings that last more than 3 years are written in red. So attention, dear judge, you have 3, 4, 5 proceedings on more than 3 years. The president of the court has also certain responsibilities for the fulfillment of this project. As we have heard, the president has to be confirmed after 4 years. So if the projects are not fulfilled, if the length of the trials is still over the overage, a president could have problems with the second term, could not be appointed for a second term of 4 years. as I said, Italian court presidents are appointed for only 4 plus 4 years, and they have no real competence to interfere with the single proceedings, but they have the possibility to recommend the criteria for the case assignment and for the distribution of the workload of the court. They have to draft every year this program mentioned in this Article 3 of the Decree 98 of 2000. It's 2011, not 2001. And they have to evaluate every 4 years the judges. Or to write reports for the final evaluation by the High Council. So if we speak about possible interference of the court presidents in the work of the single judges, maybe with these reports that they have to write every 4 years, they could in some way interfere. No? They could maybe criticize some decisions, but it's not a real competence to interfere with the work of the single judges. So, Italian judges, to conclude, should have the internal and external freedom to decide their cases exclusively on the basis of its merits, and the High Council of the Judiciary should ensure the full independence of the single judge. The question, so the Italian system is almost perfect. The answer is yes, but I've mentioned here some headlines. We had a big scandal last summer. We have always scandals in Italy, but this was one of the last scandals in the judiciary. 6 of the elected members of the High Council had to step down. The last weekend we had elections of new members, because they were involved in this scandal. Here the headlines speak about 2 councillors, but others had to step down later. It's a scandal about it's a bit. I don't have the time to speak about the scandal. Maybe we could speak in the break. It was about games of power, as it said here in the headlines, and trafficking of jobs. Mainly, the problem was that the chief prosecutor of Rome, of the capital city, retired, and the High Council should appoint a new candidate for this job, a very important job, a chief prosecutor of Rome, of the most important prosecutor office in Rome. One colleague was under investigation for corruption, and he had his cell phone wired, so a conversation was registered with some members of the High Council who were trafficking about this job. So our system is on the paper quite perfect, but it doesn't work so perfect as it should in the concrete life. Maybe this is the reason because why Italian judges feel independent, but the population sees it a bit different. So thank you for your attention.
Thank you very much for your excellent presentations, and I guess we can go directly to the discussion and ask for the questions. Mēs gribētu uzreiz uzdot jautājumus.
Let's go straight to questions without any introductions or statements. Hello, my name is... I'll wait for the others to put on the headphones. I'll give you a minute. Once again, good afternoon. My name is Martin Svitis, and I'm from the Riga district or regional court, pardon me. I think this was these were the most exciting presentations. It's always nice to listen to colleagues and what their experience is and how they feel their system works and how things are generally managed and organized elsewhere. It is always exciting, to see the sort of the nitty-gritty or hear about what actually happens. And as I was listening to a colleague from the Netherlands, from the Amsterdam court, we were talking amongst ourselves with my colleague. Could you elaborate about the guidelines? We didn't really understand clearly what those guidelines intend. Maybe it's something like we have criminal procedure law, or we have guidelines for criminal cases, civil cases, and basically there are sort of tips to follow. So what are these guidelines all about, and how do you use them? Do they apply nationally, or do you apply them only in your court? What did you exactly mean by those guidelines?
Wolfgang would like to add a question, yes.
Just because, thank you very much, because it relates to what you have presented here. This reference to the payments which you receive on the basis of numbers of cases decided, and obviously also of the quality of cases, because you referred to refugee cases being better paid. So there seems to be a system in place which doesn't work on the lowering of the funds for the courts to exert some influence, but rather on giving more and more if you decide certain cases.
Thank you very much. Two very important questions on which I could talk for hours. I won't do it, but let me start with the guidelines. Guidelines are, in fact, guidelines about the way the judge uses his discretionary power. The law cannot describe every daily situation as it comes to postponements or submitting evidence. And then you have room as judge in an independent society. And to create more certainty and more predictability for parties outside, you together make sort of standard decisions in standard situations. Those guidelines we developed in every area of law in the Netherlands. They are applied in every court. I work also in Bosnia-Herzegovina and Ukraine, and we are also trying to, and we have already developed those guidelines because they are a very good tool to fill in the space that the law provides. Of course, you have the codes, and it's not a violation of the codes, and you respect the boundaries of the codes. But within the codes, there's a lot of space and room, and if you can use that room as judge. And I think you should use that room because you're there for society. So make it clear what they can expect from you. So, that's in a short summary what guidelines for us are. So, about proceedings, procedural steps. And about the financing of the Netherlands, we are somewhat differently financed as other countries. We get a price per case. So if we do 1,000 cases, criminal cases, we get 1,000 times €2,000. From? Yes, from the state budget. In the state budget, we have the Council of the Judiciary. The Council negotiates with the Minister for the budget. And the budget, the asked budget, is based on what do we expect for cases the coming year. So we make our taxations, our assessment about how many cases are coming in this year. So maybe, as I said, 10,000 cases on small claims, 2,000 family cases, and all those type of cases have a price. So if we really decide those cases, we get that budget. And that makes us, in a certain way, more independent, because the minister cannot say, I'm going to cut your budget with 50 or 25%, as happens in certain countries. We are stick to that price per case. But that gives us, on the other hand, also difficulties, because when the income, the influx is lower, is getting lower, we cannot fire the judges. So then we have a deficit immediately. So that is our position as it comes to the finance. And in refugee cases, it is in fact this way. The government has the idea that a lot of refugee cases are, immediately clear. And if we handle those cases within 4 weeks, we get a higher price for that. And if we don't, we're just falling down to the normal price. So that is a sort of, in fact, perverse mechanism. It's a great idea. Okay, so thank you.
Thank you very much. Vai mums ir kādi vēl jautājumi?
Any other questions at this point? I also have a question to our colleague from Amsterdam Court. You were mentioning evaluation of judges' assessment. Could you perhaps explain slightly more how this is done, how often, what kind of procedure is this?
Yes. Well, in our law is set forth that every judge has an annual evaluation. And that evaluation is conducted by his manager. And that is the head of department, or from the head of department, it's the court president. And this evaluation, we have a checklist for this evaluation. And we ask feedback at the colleagues. And the judge concerned can also ask feedback from his colleagues. And then you collect all the information. And then you start this review. And in fact, we have certain standard parts, and that is, of course, but not the most important one, are you doing enough cases? We have this schedule, this employment of time. Is it functioning well, or, normally it is. And then you ask other aspects from the performance of the judge. And that is, do you often attend the meetings, the team meetings? Do you take part in the discussion about jurisprudence? Do you help other colleagues? Do you exchange your knowledge? What is your position in the court and in your team? After that, the judge manager makes a report. The judge concerned can give his view on that, and that goes to the court president, and then it is put in his file. I raised this point of, are we going to discuss in the evaluations the quality of the decisions? Sensitive point, as I said. But what we do ask is, do you have intervision with your colleagues? How do you enhance your knowledge? What do you do to improve your quality? So we ask, in fact, around the topic, we ask, what do you do to improve your quality? And it is not enough that he says, well, I read this book and that's it. No, you have to attend certain, maybe courses, or you have to take part in this reflection methods. We have more. We have the bilateral intervision, then you attend each other's hearing and you give feedback. Or you can also in a group discuss confidentiality, a certain topic which bothers you. Those are all quality measures, and in the performance review, we ask, what do you do? And it's not enough that you, no, you have to be concrete and specific. In fact, that's it.
I just wanted to ask you, Esther, if I may, arising out of that, when you get your evaluation, does that include the budget? In other words, can somebody say, oh, Esther only brought in €5,000 this month, we better have a look at And that's the first part of the question. The second part is, if you get a bad evaluation, what happens as a result?
Yeah. Yeah, well, the last question is the most difficult one from the perspective from a court manager, of court president. The first one is, no, you don't hear you have brought in 5,000 euros, but you can, well, hear your targets. We have targets, of course. We have targets as well, 80 commercial cases a year, difficult. Why did you do only 20? It will be discussed. And also, well, you did 150. Well done. Yes, well done. We can hire 2 judicial assistants by you. Well, it goes like this. But in fact, we look at it's a matter of workload, it's a matter of employment. We look at it seriously. And when judges say, well, this is really too much for me, we are going to discuss, why is that? Why is that too much? Are you maybe not capable for this area of law? Maybe you would like to go to, well, criminal law or administrative law. Not every area of law is fit for every judge. So that is how we together discuss how you, well, in fact, allocate also your judges. And the other question was, what do you do with a judge that doesn't perform well? Well, we do not have the system of disciplinary measures in the Netherlands. We have a few, but in fact we use them, well, rarely. What do you do with a judge that doesn't perform well? As I said, what's happening here? Do you need help? Do you need training? Are you maybe overburdened? Why are you not, well, why reversal rate in appeal is not a criterion as such, but if all your decisions, and sometimes it happens with a judge, that all the decisions, well, are being reversed, and you say, maybe you need some courses or some training on this matter. And what we also do is, well, I think it happens only once or twice every 4 years that you say, well, you are really not fit as a judge. And then the Supreme Court, you have to address the Supreme Court because that's the only body that can really fire, so to say, a judge. You can be fired, but what happens is, it doesn't happen often because we find a way, but sometimes a judge, well, you know, if he doesn't perform well and he got a lot of criticism, then he is always getting, well, after a certain time, he's getting sick or he's falling out. And then we say, well, maybe it's time for you. Yeah, well, that also happens. Yes, it can happen. Well, this is how we try to, well, maneuver.
Jā, es gribēju uzdot to pašu jautājumu.
Actually, I wanted to ask the same question. I wanted to ask this question to our colleague from Italy. What kind of assessment do you have in Italy? And what happens if the assessment is negative? And can this be the grounds for dismissing the judge from office?
Thank you for the question. As I said, the assessment takes place every 4 years for the first 28 years of service. So we have seven assessments. It always starts with a report written by the judge himself or herself, then a second report written by the court president, then another report by the Judicial Council of the Court of Appeal, and then the final evaluation, the final assessment is made in Rome by the High Council of the Judiciary. You can get positive, not positive, or negative. So we have 3 possible votes. If you are positive, everything okay, you get on with your career, with your salary. Not positive means that you get evaluated, you get assessed another time after a year. That means you have 1 year to improve your performance. If you are negative, but you don't, for this year you don't go on with your career, obviously. Negative means that for 4 years you don't go on with your careers. If you get a second negative evaluation, then you get fired. You're dismissed by office So 2 negative evaluations means automatically you get fired by the High Council of the Judiciary. It doesn't happen very often, but it does happen. It happens, yeah. It happens more often that you get a non-positive. That means, dear colleague, it's not so good. Your performance is not so good. We give you one year to improve your performance, and we hope that in 1 year your performance will be better, and you will get a positive assessment next year, and so you can go on with your career.
Varbūt vēl ir kāds jautājums.
Any other questions?
Thank you. Really, thank you very much for very, very interesting contributions of all of you. I have thousands of questions, but don't worry. I only will stick to 3 of them, so one to each of you. I was surprised. I was surprised by the system of appointment of presidents of courts in the Netherlands, because, I mean, the CCG opinion number 19 on roles on presidents of courts determines that ideally, and they recommend that they should be appointed the same way as the judges. And it appears that it's different. I wanted to know your opinion on how would you assess a system where presidents of courts, like I think it's Latvia, are appointed by the Council and the Ministry of Justice? That would be one of the questions. The second question would be for the Irish judge. I would like to know your recruiting system, which is based obviously on experience and seniority and previous career. You said that there is an advisory appointment body established. Who appoints the advisory body? And in order to determine how far it is from the executive. And the last question for the Italian judge. Isn't it, it's quite surprising that the president of the High Council of Justice, so the self-governing body of the judiciary, is presided by the president of the Republic. So it makes clear we are separated, but I have here the presence and the presidency of your body. I would like to know how is it seen from the inside, because from the outside it looks very badly. Thank you.
Thanks. So, Lorena, you're asking me how is the body that recommends judges in Ireland appointed? In fact, it's a statutory body that has statutory members. And when I say statutory members, automatically the Chief Justice is a member, the President of the Court of Appeal is a member, the President of each of the courts is automatically a member, and then the professional lawyers' bodies, for example, the Bar Council, the Chairman of the Bar Council is a member, the President of the Law Society that represents solicitors is a member, and then there is one member, I think, directly appointed by the Minister who is a non-lawyer, but that is the only non-lawyer on it, and the Attorney General is also automatically a member. So it's sort of a fixed membership that obviously fluctuates as the office holders change. Yeah. Does that answer your question? Yeah. Yeah.
Thank you. No, in Italy, I think the presence of the President of the Republic and the High Council, as a head of the High Council, is seen as a guarantee of the independence, because the President of the Republic in Italy is not an expression of the executive power, of the legislative power, and the President of the Republic has to be elected by a 2/3 majority of the Parliament. That means the President of the Republic, normally he or she is a politician, but not coming from a party, but a person who guarantees the independence of the. Yeah, should. And normally the Italian presidents are respected persons. So different from the prime ministers maybe, but because as I said, they have to have to reach a very strong majority in both chambers of the parliament, as to a third majority. So normally there are high respected personalities, and it's also to say that the President of the Republic normally doesn't participate in the daily work of the Supreme Council. No, it's indeed the real president is the vice president. The vice president is a politician. The vice president is one of the 8 members appointed by the parliament. So the real chief in the daily work of the Supreme Council is one of the vice president. It's Mr. Eminini nowadays, and he is a politician. Yes. So the President of the Republic makes some opening remarks at the beginning of the working session, but he doesn't participate, obviously, in the daily work of the Supreme Council. But I think it's not seen as a interference of politics in the work of the judiciary.
Well, thank you for allowing me to say something about our system in this respect. I did not have enough time, but there are things going in the Netherlands. At the moment, court presidents are appointed by the Council for the Judiciary and in the end by the minister. But every judge and everyone is in the end appointed by the minister. So what is here the political influence? Well, the political influence, in my opinion, at court presidents is in fact, well, no, not there. Members of the council at this moment are under a sort of, pressure to change their composition because our judges, a lot of our judges in the Netherlands, think that they suffer, say they have too much influence from the Minister of Justice because the Minister of Justice has to agree with who is going to be the President of the Council. At this moment, there is no minister that would say, I don't agree with the chosen one. But we, at the moment, have some political changes. We have a strong right wing upcoming, and we are, at this moment, thinking about, well, suppose this person is going to be the Minister of Justice. And he says, well, this President of the Council, no, because President, you appoint court presidents who do, for instance, too many refugee cases or not enough refugee cases. Please send them all away. Well, so we are now reconsidering the influence of the minister on the council, and the appointment of presidents is also being changed. But the reason for that is that persons on the shop floor want to have more influence. So judicial assistants and judges. And they advise at the moment, but they don't have a decisive voice. And that's what we're going to change now. Well, that's in a nutshell. Sorry to be so long, but this is happening, yes.
Thank you very much. Yeah, varbūt jautājumu.
Any other questions? If we have no more questions, then I would like to thank our speakers.
All the presentations, and now we will break for the coffee break, un tad mēs šobrīd apstājamies uz kafijas.
So we break for coffee and we reconvene in half an hour's time.
Well, I hope you've all had plenty of coffee because I'm about to challenge your ability to stay awake. I'm going to talk about courts and the media from the perspective of the Irish courts, obviously, because that's my experience. And like I think Laura earlier on, I'm not technological either. In fact, I'm in the Stone Age when it comes to technology, so I have no slides, so I hope you'll bear with me. Wolfgang tells me, however, that the paper will be digitally available in Latvian in due course. So, courts and the media. So, two of the key pillars of the rule of law, judicial independence and freedom of expression, more particularly freedom of the press. As we know, the two don't always sit comfortably together. I think this is particularly so in countries where the worldwide phenomenon that is the rise of populism is most keenly felt. In turbulent times, tensions inevitably arise between these cornerstones of democracy. The job of the courts, as we know, is to uphold the rule of law, no matter how unpopular that may be, and there have been many recent examples of media backlash against judges who are simply doing what they swore to do when they were appointed. This has reached something of a low recently in Ireland's neighbouring jurisdiction, the United Kingdom, where the judges who decided the first Brexit case were labelled in the tabloid press as enemies of the people. Only a few short years ago, it was unimaginable that the President of the United States would publicly criticise named judges for deciding cases against the administration, even to the extent, as I'm sure you all know, of accusing one judge of being partisan due to his ethnic origin. How to respond, I should say about that of course is Judge Curiel, who decided a case involving Trump University, and I understand the President has revised his view of Judge Curiel because some of his recent decisions were in favour of Trump University. So apparently he's a very good judge, it seems. How to respond, though, to such unfair criticism is, I think, for judges a difficult question. Apart from dealing with the news media, courts are increasingly facing the difficult problem posed by interference with the legal profession on social media. In this discussion, I'd like to deal with three aspects of the court's interaction with the media where issues have arisen. The first is criticism of the judiciary. Secondly, publication prejudicial to proceedings. And thirdly, protection of journalist sources. And as I think I said earlier, in doing this, I'm approaching it from the perspective of the Irish jurisdiction, which, like the UK, is a common law jurisdiction. So dealing firstly with criticism of judges, judicial independence, as I mentioned earlier, in Ireland is guaranteed by our written constitution, which enshrines the doctrine of the separation of powers. Article 40 of the Constitution guarantees freedom of expression as an enumerated right, but it does provide that organs of public opinion shall not be used to undermine public order or morality or the authority of the state. Article 10 of the European Convention on Human Rights specifically allows for limitation on freedom of expression in order to maintain, quote, the authority and impartiality of the judiciary, unquote. Of course, a certain level of criticism of judicial decisions, as opposed to judges personally, is to be encouraged in any healthy democratic society. But the difficulty, I think, lies in determining where the boundary between criticism that is reasonable and that criticism which is not. And the need for a level of restraint in media criticism is recognised in the Mount Scopus International Standards of Judicial Independence now some years ago. Article 6 of the Mount Scopus Standards deals with the media and the judiciary, and it says it should be recognised that judicial independence does not render judges free from public accountability. However, the media and other institutions should show respect for judicial independence and exercise restraint in criticism of judicial decisions. While recognising the general right of freedom of expression of all citizens, a judge should not intervene directly with the general media. If a judge needs to respond to the media in regard to a media report or inquiry, it shall be done via a spokesperson assigned by the court or a judge specifically assigned by the court for this purpose. In exceptional circumstances, a judge may respond directly to the media if that judge's direct response will prevent irreparable damage. The media should show responsibility and restraint in publications on pending cases where such publication may influence the outcome of the case. And then finally, a judge shall not knowingly, while a proceeding is or could come before the judge, make any comment that might reasonably be expected to affect the outcome of such proceedings or impair the manifest fairness of the process, nor shall the judge make any comment in public or otherwise that might affect the fair trial of any person or issue. So nothing really controversial there, and I suspect things that we all instinctively understand. In both Ireland and England, over-the-top criticism of judges used to be dealt with by the rather nebulous common law offence called scandalising the court. It has recently been abolished in England and Wales, but still subsists in Ireland. The last successful prosecution of the offence in England took place in 1900. when the editor of the Birmingham Daily Argus published the following remarks about Mr. Justice Darling, who was presiding over a case concerning the publication of certain obscene words and the publication and sale of indecent books, and I quote, "No newspaper can exist except upon its merits, a condition from which the bench, happily for Mr. Justice Darling, is exempt. There is not a journalist in Birmingham who has anything to learn from this impudent little man in horsehair, a microcosm of conceit and empty-headedness." In the subsequent prosecution of the editor for scandalising the court, the High Court in England held that any acts done or writing published that are intended to lower the authority of a court or judge amount to contempt of court by scandalising. The court added that reasonable criticism of the court is legitimate, but the article in this case was found to go beyond acceptable criticism, the comments being personal, scurrilous abuse of a judge as a judge. The editor of the newspaper was fined £100 and ordered to apologise. And I think you can detect from that why there hasn't been, in the last 100 years, a successful prosecution for the same offence, in England at any rate. A more recent example in Ireland occurred in a case called the State Director of Public Prosecutions versus Walsh and Keneally. So save in the case of a minor offence which may be tried summarily, our Constitution provides in Article 38.5 for a right to trial by jury in all criminal cases. An exception to this is the statutory jurisdiction of our Special Criminal Court, which is a non-jury court founded primarily to try cases involving terrorist organisations such as the IRA and also gangland crime, where concerns arise as to the suitability of juries to try such cases. Mr. Walsh and Mr. Keneally were convicted of contempt in the form of scandalising the court based on the content of a press release they had authorised, which was published in the Irish Times newspaper. The press release attacked the legitimacy of the Special Criminal Court and alleged that the court had so abused the rules of evidence as to make the court akin to a sentencing tribunal. The defendants did not dispute that the statement amounted to scandalising the court. They argued, however, that this meant that they were charged with a serious crime and so were entitled to a trial by jury under the Constitution. The defendants conceded that some contempt cases could be dealt with summarily, that is, without a jury, where it was necessary for the court to act quickly in the interests of justice. But this was not necessary in cases of scandalising. The Supreme Court, that's the Irish Supreme Court, concluded that the courts could deal with contempt cases summarily where the facts are not in dispute, such as in this case, and that the defendants were therefore not entitled to a jury trial. More commonly, however, rather than the offence of scandalising, such cases as I've described are simply dealt with as contempt in the face of the court. Thus, in the case of Kennedy and McCann, the Sunday World newspaper published a story about a custody case between a husband and wife, which was pending in the Supreme Court. Such cases are, I suspect, everywhere heard in camera, and the identity of the parties and their children anonymised. The newspaper not only published the names of the parents and the children with details of the marriage breakdown, but also photographs. The article alleged that in the custody case in the Irish courts, the welfare of the child was not treated as the paramount consideration, but instead money and lifestyle were regarded as the most important criteria applied by the courts. The article also implied that justice could not be obtained in Irish courts, and in this respect, Ireland was a sick society which was hypocritical about motherhood, morality, and the family. The Supreme Court disagreed. They found that this went beyond acceptable limits, and the article amounted to contempt on two counts. Firstly, that it was a breach of the in-camera rule, and secondly, it was a publication of material intended to scandalise judges by accusing them of having corrupt and improper motives. Although probably beyond the scope of this talk, the whole area of contempt in the face of the court, a common law offence, is problematic in the Irish jurisdiction, where it is thought essential that the court have power to deal immediately and summarily with contempt in the face of the court, so as to protect the court's own process and prevent deliberate disruption. The potential problem, however, that can arise in this regard was highlighted in the decision of the European Court of Human Rights in Cipriano and Cyprus, a 2007 case I'm sure most of you are familiar with. That was a case in which the court imprisoned a lawyer for contempt by directly insulting the court, and it was, according to the European Court of Human Rights, a breach of Article 6 of the Convention, where the judges acted as complainant, witness, prosecutor, and judge. In general, however, I think it's fair to say that in Ireland we're fairly fortunate in that media and politicians alike are restrained in their criticism of decisions, and particularly of judges personally. Indeed, I can't think of any recent occasion when a judge has been personally subjected to unfair criticism. However, our judicial colleagues in the neighbouring jurisdiction have not been so fortunate. In a recent lecture entitled Moral Courage in the Law, the President of the UK Supreme Court, Lady Hale, gave some recent examples, and I quote, "The media can react strongly and personally against those they perceive to be acting against the media's interests. An example is the case of PJS, a Newsgroup Newspaper Limited, where a majority in the Supreme Court upheld the grant of an interim injunction to prohibit the publication of the identity of a married person caught up in a sex scandal, a matter of no public interest whatsoever, but a matter in which the public were intensely interested. We were ridiculed. I was reportedly known for my radical liberal ideas and also known as Ms. Diversity, neither apparently a good thing, while the dissenter was praised. Ironically, despite this, the newspaper settled the case, agreed to pay damages and to maintain the anonymity of everyone involved." And Lady Hale continued, "Then perhaps fortunately most senior judges do not engage with social media or the tabloid press. This may or may not be a good idea, but it does mean that we can and should ignore or brush off such personal taunts. But the rule of law may be put at risk if the media goes too far. The most obvious recent example is the case of Miller and the Secretary of State for exiting the European Union, a 2018 case. The question was, could the government rely on the royal prerogative to trigger the process of leaving the European Union, or did they need the sanction of an Act of Parliament? Because of the importance of the case, it was heard by an unusually strong divisional court consisting of the Lord Chief Justice, the Master of the Rolls and Lord Justice Sales. When they handed down judgment against the government, the Daily Mail published pictures of the three over the banner headline, "Enemies of the People, Fury over out-of-touch judges who defy 17.4 million Brexit voters and could trigger a constitutional crisis." And with that background, no doubt the Supreme Court were eagerly looking forward to hearing the appeal. Lady Hale then takes up the story. But then the press caravan moved on to the Supreme Court, where for the first time in living memory, all 11 then serving justices sat on the panel. Was taking this unusual course simply a wise way of protecting the court from an accusation that the result might have been different had a different panel been selected, or was that too succumbing to media pressure? At least, as Lord Justice Sales put it, the 11 of us afforded a more diffuse target. But this did not stop the Daily Mail from singling out 4 justices for their alleged European links and sympathies, describing Lord Reid, for example, as a Brussels man to his fingertips. Andrew Pearce in the Daily Mail wrote, "And now here is the next lot lining up to have a go, judges who will rule on Brexit impact." How wrong they can be. The two of the 4 alleged Europhiles dissented from our decision to uphold the Divisional Court by a majority of 8 to 3, but the Daily Mail's response to our decision was very clever. They published the same size pictures of the 3 dissenters under the banner headline, "Champions of the People." Some judicial commentators have remarked on the fact that the focus of the media and political criticism of judges has changed significantly in the last few decades. In his article entitled "Judges on Trial, the Independence and Accountability of the English Judiciary," Mr. Justice Potter of the English High Court said, "The High Court judge was, in the late 1980s, typically portrayed in some parts of the media as a port-soaked reactionary, still secretly resentful of the abolition of the birch and hostile to liberal influences of any kind. The same judge is now in the same parts of the media an unashamedly progressive member of the chattering classes, spiritually if not actually resident in Islington or Hampstead, out of touch with ordinary people and diligently engaged in frustrating the intentions of Parliament with politically correct notions of human rights." Another senior British judge, Lord Dyson, said in 2014, the tenor of much media criticism against judges has moved away from complaining that judges have too much sympathy for the interests of government and the establishment towards judges being too disruptive of those interests. How then should judges respond to criticism? The traditional view has always been that a judge should simply turn the other cheek and stay silent. As long ago as 1625, Sir Francis Bacon, who was then the Lord Chancellor of England, wrote, "An over-speaking judge is no well-tuned cymbal." However, there comes a point when some form of response is necessary if public confidence in the administration of justice is to be preserved. However, in my view, the response should never come from the judge directly. That is consistent with the Mount Scopus standards to which I have referred. Again, quoting Lord Dyson, responses to criticism pose a threat to judicial independence on two fronts. A response may give the appearance of the judge stepping into the political arena. In turn, this may raise doubt about the judge's ability to make objective judgments about the relevant legal issue. If judges comment on cases outside court, they undermine the integrity of what they or their colleagues have said in court. One of the difficulties we have faced in Ireland in recent times is that there has been no formal institution to speak on behalf of the judiciary, despite the fact that we have actively sought it for over 20 years now. Thankfully, in the last few months, the Judicial Council Act has been passed, which will establish a judicial council as of February next year that has wide-ranging functions, including promoting and maintaining respect for the independence of the judiciary and public confidence in the judiciary and the administration of justice. The Council will shortly be established and hopefully will equip itself with a press office which will, when necessary, deal with issues of the kind we are discussing. Up to the present time, the vacuum that has existed in the absence of a judicial council has of necessity been filled on rare occasions by our judges' trade union, the Association of Judges of Ireland. The AJI was recently called upon to intervene on behalf of my colleague in the Court of Appeal, Ms. Justice Aileen Donnelly, then a judge of the High Court. We've discussed this case earlier, as you will recall. Judge Donnelly was the judge in charge of dealing with European arrest warrants, and I covered the facts of the Selmer case. She was concerned that the evidence that the rule of law was systemically damaged in Poland was significant, and she requested a ruling from the ECJ on that. But the relevance to this part of my talk is that this provoked a media storm in Poland, where the gutter press made outrageous personal remarks concerning the judge's sexual orientation. Such an attack on an Irish judge was unprecedented and moved the AJI to issue a press release which said, any interested person or parties are entitled to criticise a judgment. However, a judge is a public office holder and the criticism should be confined to that and directed at the court's decision and not the judge personally. The irrelevant references to Ms. Justice Donnelly's personal and private life are utterly unacceptable. Somewhat ironically, as we've heard, Ms. Justice Donnelly ultimately extradited Mr. Selmer to Poland, and her decision was upheld by the Supreme Court. One area that frequently draws uninformed criticism from the media is that of sentencing in criminal cases, particularly in the context of sexual offences. Judges are not infrequently indirectly criticised in the media, more often than not, for being supposedly too lenient. Almost always the criticism is entirely misplaced and stems from a misunderstanding of how sentences are arrived at. I think one of the main culprits here is the fact that traditionally in common law jurisdictions, sentencing courts do not give written decisions. This often results in inaccuracy in reporting and misinformation in the media. And indeed, one area in which my colleagues in the High Court have direct experience interacting with the media is in the context of referendum commissions. Whenever our written constitution requires amendment by referendum, there is a statutory requirement for the establishment of a committee in relation to such referendum, which is chaired by a High Court judge. Its function is to disseminate impartial information about the referendum and encourage people to vote. There have, I think, been about 19 referenda in the last 20 years, including very controversial topics in Ireland, such as abortion and same-sex marriage, which naturally attract huge media attention. The commissions are generally well-resourced and have media teams at their disposal. One of the judges I spoke to who recently chaired such a commission told me that her media team repeatedly emphasised the need for the fullest possible information, ideally in writing, to be furnished to the media so as to avoid misunderstandings potentially leading to unwarranted criticism. I'm turning now to the issue of publication prejudicing media trials, or prejudicing trials rather. This again is more, I suppose, commonly known as the sub judice rule, and is a particular branch of the law of contempt of court. It's designed to protect the administration of justice by preventing trial by media. In DPP and independent newspapers, Ms. Justice Dunn, then of the High Court in Ireland, who is now a Supreme Court judge, explained that the test for sub judice contempt is whether the material published was intended to interfere with the administration of justice or created the perception of such interference. It's not necessary to show that this interference has actually occurred. The question is whether there is a real risk that the accused will not receive a fair trial following the publication in question. In Ireland, sub judice contempt is again a creature of the common law, which, as we have seen, can give rise to problems of uncertainty. It's probably the area that brings the court most commonly into conflict with the media. It is of necessity an infringement on the right to freedom of expression. This issue was considered by the Strasbourg court in the case of Sunday Times in the United Kingdom, which was a 1979 case. The Sunday Times newspaper published an article about thalidomide at a time when there were many claims pending before the English courts concerning its use. The newspaper article alleged that the manufacturer of the drug was aware of the risks it posed to pregnant women and their unborn children. This was clearly a central issue in the proceedings. The Attorney General sought an injunction prohibiting the Sunday Times from publishing any further articles and also prosecuted the newspaper for sub judice contempt. The House of Lords, which was the immediate predecessor of the current Supreme Court in the UK, ultimately held by a majority of 3-2 that the articles were in contempt of court and their publication was not justified by a defence based on freedom of expression. However, the European Court of Human Rights disagreed and held that the injunction violated Article 10 of the Convention. In Ireland, in a case called Cullen and Tobin, McGill magazine published an article about a woman who had been a witness in the murder trial of one John Cullen. The article was published post his conviction, but while an appeal to the Court of Criminal Appeal was pending. The Supreme Court refused to prohibit the publication on the basis that it was unlikely to prejudice judges of the Court of Criminal Appeal in their determination of what were pure legal issues. But in contrast to that, the Supreme Court held that contempt did arise in another case called Kelly and O'Neill, where Mr. Kelly was convicted of drugs offences and was awaiting sentence. Prior to the sentencing hearing, the Irish Times newspaper published material which was not admissible in the trial but was clearly prejudicial to Mr. Kelly. Although the trial judge stated that he had not been influenced by the article, the Supreme Court concluded that the accused may nonetheless have felt that the trial was unfair and might question the impartiality of the judge. The court held that the test was whether the material was intended to interfere with the administration of justice and not whether it had actually done so. It prohibited the publication until the sentence had been passed. The sub judice contempt issue was recently to the fore in Ireland in a very high-profile criminal case. This involved the brutal murder and sexual assault of a 14-year-old schoolgirl called Anna Kriajel. Two 13-year-old boys who were schoolmates of the victim were convicted of her murder and one of her sexual assault. Nothing of the kind had ever been experienced in Ireland before, and the lengthy trial that ensued gripped the nation. There was a predictable media frenzy surrounding the case. The trial judge, Mr. Justice McDermott, had his hands full in ensuring, first, that the anonymity of the children was protected, and second, that no inaccurate prejudicial reporting appeared in the press. On day 2 of the trial, the Irish Daily Mail published a front-page headline reading, "CCTV shows Anna being led to her death." In fact, no witness had given evidence to this effect. Mr. Justice McDermott charged the newspaper and its editor with contempt. The paper pleaded guilty, but the editor did not. The judge considered that the headline gave rise to a real risk of injustice and a real potential to put pressure on the two accused boys, boy A and boy B. It was particularly damaging to boy B, as it was alleged in a sentence in the news report that it was he that was leading Anna to her death. The court found the editor guilty of contempt and fined him €4,500. The newspaper was fined €25,000 and was restricted from further reporting on the trial, probably in reality a more severe penalty for the newspaper. Another huge challenge in this particular case was presented by the use of social media. Shortly after the trial commenced, the names of the accused children were all over Facebook and other social media, and indeed there may yet be prosecutions arising from this. The publication was obviously very serious because it violated the anonymity of the children involved, but it was particularly serious not just for those obvious reasons, but because it emerged that there was a boy in the same school as Anna and the two boys in question with the same name as boy A, whose life was endangered as a result of the publication. This is a far more difficult issue to deal with than publications by news media, and I suspect that's going to occupy a lot of us a lot more in the future. Finally, I'm just going to deal with the subject of protecting journalists' sources. Any witness giving evidence in court is obliged to answer relevant questions, and a failure to do so can be regarded as contempt in the face of the court. For journalists, this most starkly arises where they are required to give evidence and asked for the source of their story, which may bring them into conflict with their professional code against revealing confidential sources. This is potentially a serious matter for the journalist concerned, because not only does he or she risk loss of access to confidential sources in the future, but the journalist's very livelihood may be threatened if he or she were to risk losing membership of the Journalists' Union, the National Union of Journalists, for breaching its professional code. In Rio O'Kelly, a 1974 Irish case, Mr. O'Kelly, who was a television journalist, was called to give evidence in the trial of a person charged with membership of an illegal organisation, the IRA. The prosecution contended that the accused was the person who had given an audio-taped interview to Mr. O'Kelly, where the person on the tape claimed to be the chief of staff of the IRA. Mr. O'Kelly was asked to disclose the identity of the person whose voice was recorded, and he declined to do so. The Special Criminal Court found him guilty of contempt and sentenced him to 3 months' imprisonment. On appeal, the Court of Criminal Appeal held that journalists do not enjoy a constitutional immunity from disclosing information received in confidence, and upheld the finding of contempt. However, having regard to the fact that the accused was in any event convicted, the sentence of 3 months was set aside and a fine was imposed instead. That decision, however, has to be viewed in the light of the subsequent judgment of the Strasbourg Court in Goodwin and the United Kingdom in 1996. Mr. Goodwin was a journalist who received information about the financial problems of a company from a source who wished to remain anonymous. The company obtained an injunction prohibiting publication of the information and an order requiring Mr. Goodwin to reveal his source. He declined, and he was fined £5,000 for contempt. The Strasbourg Court held that the disclosure order violated Article 10 of the Convention. The court noted that the protection of journalistic sources is one of the basic conditions for press freedom. Without such protection, sources could be deterred from assisting the press and informing the public on matters of public interest. The court was satisfied that an order requiring disclosure of a source could only be justified by an overriding requirement in the public interest. The Goodwin case was considered in Ireland by the Supreme Court in Mahon and Keena and Kennedy in 2010. 2 journalists were charged with contempt for writing an article based on information from a confidential source, which included a letter written by a statutory tribunal of inquiry. The tribunal was inquiring into corrupt payments to politicians in connection with building permits. The letter revealed information about evidence that might contradict evidence given by the then Taoiseach, the Irish Prime Minister, who was also a witness before the tribunal. The High Court ordered the journalists to appear before the tribunal and answer questions concerning the source of the information, and they declined. They appealed to the Supreme Court, which held that the Goodwin decision does not give journalists a right to have their sources protected in all circumstances. The court considered that no citizen has the right to claim immunity from the process of the law. Where the information is required for the proper administration of justice, the court must decide whether the source should be revealed. In doing so, the court will allow all due respect to the principle of journalistic privilege. In the present case, the documents sought by the tribunal had been deliberately destroyed by the journalists, and so the court could not identify any sufficiently clear benefit to the tribunal that would justify the making of a disclosure order. The court therefore refused the application for disclosure. Just in time, thank you very much. Stay here or to...
Before this move is concluded, I would just like to add one comment, perhaps, on what you said with regard to, in particular, the tabloid press in the UK and the enemies of the people picture. I think this just represents this conflict, which also is used, played by many populist governments nowadays, between the real democratic will of the people, which they pretend to only know, and the judges, which are put in a position as if they were representing just individual or single opinions or positions, which is insofar true as, of course, the role of a judge is to protect, under fundamental rights aspects in particular, the individual against a majority, even a majority decision. There might be a law which is contravening fundamental rights, and for that reason cannot be enforced against a given individual which has fundamental rights which are stronger. But I think this is a phenomenon which we have to analyze very carefully and keep in mind that this is really a risk for judicial independence as such and for the role of the judiciary in all of our countries, because it comes under the surface. It plays with images which people don't understand, because they don't understand very often this inherent conflict between majority will and the fundamental rights, which only make, together with the rule of law, the rule of law as such operate. Thank you.
And we have one more panel to go, and we would like to pose a question to all the panelists. So, given your particular experience, how do judges in your country use social media, use online solutions, and how do judges in your country respond to various crises? So what's the crisis response of judges?
Yes, it's a big problem in Italy, the use of social media by judges. Also photos published on social medias. If you give me a second, I can show you a photo that was in the Italian media. I have it here for by case because I used it. If I'm sorry, I used it a few months ago in a conference in Berlin for the German Judicial Academy. It was about judicial ethics, but I'm not sure if it was the photo of a public prosecutor at the private party, together with a lawyer, and the lawyer was kissing the feet of the prosecutor. If Anna can help me, maybe I will. Okay, where's the cursor? I don't see. Do you know? Okay. Give me a few seconds. Okay, here we are. Okay, that's the photo. As you can see, it was a private party. That's our colleague, a prosecutor. It must have been a funny party because the dress is a bit wet, and the guy here, well, he's more licking than kissing the feet, but he's a lawyer. The problem was that she was investigating against for a train accident with some deaths, and the lawyer was the defense lawyer of one of the main investigated person. So the poor colleague had disciplinary proceeding because of this behavior, but obviously her defense was, well, it was a private party. It was fun. I didn't even notice that someone took a photo of me and of this. It was a joke. Now this lawyer kissing my feet. That's a title of Italia Oggi, of a newspaper. Non si baciano I piedi ai magistrati. Don't kiss the feet of a prosecutor. Translated. Okay, so. Well, that's another photo. It's another problem. Always a prosecutor, female prosecutor, had a problem because she was called to a house where an explosion has happened. So they thought about a terrorist attack. It was the house of a famous singer, this guy here, named Darko, and she posted this on her Facebook account with her friends. Oh, I met Darko. Wow, a beautiful guy. And her friends answered her, oh, how is he? And the chief prosecutor heard about this, and she had the disciplinary proceeding too, because it was said, you as a prosecutor, you shouldn't post on your Facebook account things about your work. You know? If you meet a famous singer, a famous actor doing your work, you shouldn't write about this on your Facebook account. Okay, that's the last photo. It's the man in the middle of the girls. It's a colleague from the Italian State Council. He was dismissed from service because of his behavior. He organized some seminars, courses for future judges, especially for female judges. And he was also indicted for misbehavior, for sexual misbehavior against his students, female students mainly. He introduced a sort of dress code in this school. And for certain parties, the dress code was this mini shirt. So 3 examples of misbehavior of judges in Italy on social medias. Yeah.
So what could I add more than what Stefan already said? But if I'm allowed, I would like just to specify a little thing about not on the social media, about social media and judges' social media, but about judges' skill with internet. Because in Italy, for example, we have for civil cases, all lawyers are obliged to deposit all documents electronically. And that requires judges to know very well all the electronic system. But at the same time, lawyers had to deposit the hard copy. So we have a double work. We have to deposit all documents electronically, but at the same time we have to deposit hard copy. So lawyers would like judges to be so good with social media as with electronic system, in order to avoid lawyers to deposit also hard copy. And we do appreciate, lawyers do appreciate if judges can learn better electronic system for all the electronic deposit. That's my critique about judiciary system in Italy.
Yes. The problem is that the lawyers write too much, and it's more easy to read the document on a paper than read an electronic document if the lawyers read hundreds of papers. That's the main reason. But
you should think about the paper. So if we, yes, Greta Thunberg could give some lesson about it.
Thank you. So I suppose my view about social media, again, going back to the fact that I'm not very technological, is that judges should avoid it if they can. I certainly have. Even before I became a judge, I wasn't on Facebook, but that's more a reflection on me than anything else. But I think the problem really with social media is that people tend to be somewhat uninhibited when they're speaking on social media, and they say things that they mightn't otherwise say or do, or post pictures that they mightn't otherwise post, as we've seen from Stefan's very helpful illustrations there. I'm sick telling my children not to put anything on social media that might come back to haunt them in years to come, and I always tell them to think of it as if they're presenting it to an arena full of thousands of people and live on stage, and would they do it in those circumstances? They ignore me anyway, needless to say. But I think the problem also has been particularly difficult in Ireland from the judge's perspective, because in Ireland we're still dealing with the fallout, as I'm sure a lot of you are here too, from the economic recession. And this means that there's a huge amount of bank debt cases before our courts constantly, and also claims repossessing people's homes where they've defaulted on mortgages, where they bought properties for huge amounts of money back in what were called the Celtic Tiger years, which are now all in negative equity. And the situation has actually become worse as a result of the fact that many of the mainstream high street banks have sold their loan portfolios to what are primarily, I think, American vulture funds, who have come in, and they're basically trying to recover whatever they can on loans that they have acquired pretty cheaply, because they're a bit like junk bonds. They're not worth very much, but they don't have the same sympathy, as it were, for the unfortunate debtor as perhaps the banks might have had, although that's probably a bit of a myth as well. But the problem really that this has given rise to in Ireland is that because these foreigners are perceived as putting Irish people out of their homes, it has caused a groundswell of public opinion, particularly manifesting itself in groups who try to thwart cases before the courts. These are sort of pressure, agenda-driven groups who have caused us a great deal of difficulty in the Irish courts. And one of the tactics these groups employ, and it's very disquieting, I have to say, for judges, but they conduct quite detailed and extensive research online into judges' personal lives, and not just that, but their business interests, or their family's interests, their wives, their husbands, their partners, their children, whatever it may be. And very often these people will arrive into court and start reading out to the judge in question what they've gleaned about him or her online, and it's very distressing, and it's designed to be intimidating. And of course this all comes about as a result of the digital age, but I've certainly seen some colleagues of mine visibly seriously upset by what they had to encounter at the hands of these people in court. There's no real sign of it abating, but I think it simply goes to emphasize the dangers of any online presence. It's impossible to avoid it. Every judge is a public figure, and there's bound to be stuff in the media or elsewhere about the judge that you just can't do anything about it. I think all you can try and do is minimize your profile in the media as much as you can. But certainly insofar as putting anything onto Facebook or any of the other Instagram or whatever it may be, I think it's largely to be avoided if at all possible. Thank you.
Thank you. I will be very short. I tend to speak too much, but this time I will be very short. My position is when we're talking about judges and media, we're talking two topics, obviously. Media against the judges, so freedom of press and the possibility of influencing on the independence of the judges, which has been already very much addressed by my colleague, and the other way around, judges using the social media. And what happens with judges using the social media is that they increase the risk of putting a bias or damaging the image of impartiality or the so-called dignity of the judgeship. What is the when I'm do training of judges, put it very short. What should not be put online and how you should behave online, exactly the same as in non-digital life. So you would not say the same things, you would not appear in online as out of line. Obviously online it has a huge more repercussion and an impact and potential impact to spread around. If we start dancing in this room and no one has a camera, it remains among 40 people, no? But if you put it in Facebook, so the potential impact is much broader. So if something you would not do in your real life, because you consider, I mean, this is improper for me, and I would be ashamed of it, and someone could tell me, I mean, this is against dignity, then you shouldn't do it online. Now the question is, what should not be done? And what is damaging the image of dignity or the duties of proper behavior of a judge? That's a very difficult issue, very difficult answer. And obviously, I'm not taking all the evening to explain to you all the many cases because it's so much context-based. It depends on the social environment, cultural environment that precise judge is working in. To terminate and to close, when we talk here about, and this has been the traditional position, do use of the self-restraint. Do apply the maximum discretion. Why? Because so you do avoid the risks. But this is kind of avoid getting on the street or driving a car if you don't want to have a car accident. Of course, that's the easy solution, no? But it's easy for us because we are already a little bit older. But when I'm training junior judges, you simply cannot tell them, don't get online. Because online is for them like breathing. It's part of their life. So you can do to a 20-something old person, be a judge or another one, impose a sanction, but never, never get away the mobile phone because this is already infringing not their privacy, but their development as a social being. So if we understand this from that point of view, it's absurd that we say, don't use social networks. Try not to write anything on Twitter. Don't put any picture on Instagram. The only recipe is don't put anything that you would not do in the physical world. But there are no other recipes, believe me. And I have been seeing so many single cases like these ones in feasts, in parties, and so forth. On the other side, we would consider this, is this improper? Well, it depends how the judgment was at the end. I wouldn't mind if, okay, they are having fun, they are having a party. I think it's absolutely unethical and immoral that someone distributes it in order to affect and damage the image of the single judge. I don't think the judiciary as a whole is damaged, because we all know every judge of us behaves in the private life and can get to a party and can dance and can even drink sometimes. No? But when it affects something that is really unethical, and the problem in the pictures you were putting was not that they were licking the feet. This was also, Ferguson in the royal British family sometime was very scandalous. But the scandal thing is that it's one of the parties or someone linked to the parties. Then the impartiality is really affected. And we should then really, in assessing if this is an improper behavior, differentiate. Does this affect any pending case, or is there any information, or this behavior affects the pending case? Second, it's related to political matters, and this may cause a bias and of the judge and the judiciary as a whole. And finally, if the expressions or the declarations or the statements made, whatever, online or in the press or in TV, it's done on behalf of the judiciary, because this has the capacity much more to affect the whole of the judiciary, but on the other hand, they are legitimized in their freedom of expression. So, sorry, I always tell I'm being very short, but I can't, sorry. Thank you.
Well, I think everything has been said by my colleagues, and I agree, although you do not agree on everything. I think it's very much depending on when is an act behavior is well not okay. It depends on the circle around you. What I do with my family and with my daughters is something different that I would do with my friends, and then I have friends and I have, well, persons that I know, and then we have this big circle of your professional life. So I think it depends on in what circle you are to assess if behavior is okay or not. And I also think we have to adapt ourselves, because this is changing. 10 years ago, I remember I fired a colleague from the administration because he was using Facebook on his screen. And yes, but I would never do it again, because everybody uses Facebook or anything on his screen and works and has this glimpse. You can say, well, then you're not so very efficient in the work that you have to do for the court, but it would not be a reason to fire somebody. So we change, and I think this is also a learning process, and we have to be adapted to society, but we should not, on the other hand, change, I think, too fast, because then we harm our image, and our image is also that we are not, well, in fact, we're not the most modern types, so to say, and that gives a sort of feeling that we are this, how do you say that, this point of rest and this point of distance and this point of objectivity. And I think that has all to do with the image of the judiciary. So I think that's also a relevant point, the image, our image. Okay.
If I may add some comment as well. And I'm, of course, also of the generation which is not present on social media almost at all. I think we have to distinguish between, really, as you said, Lorena, how we behave, and which is attributable to us. And then if I behave like he behaved, and that is filmed, well, then bad luck for him. But I think it was appropriate that he was not kept in the Consiglio dello Stato, no? But if someone digs in the past, and you have behaved perhaps as Justin Trudeau many years ago when you were a student, you painted your face black because that was absolutely innocent at the time. I still consider that innocent personally, but nevertheless. And now it's played against you because you are hearing a case. And it might be more difficult if we are hearing a case which involves parties who have a different ethnic origin, then it gets very difficult. And then, I mean, sometimes I think that the contempt of court construction which you have might help or might not. But insofar, there is no obvious solution. Because when you are young, you are certainly less cautious, even if you are less cautious, in particular if you are still a student and don't think of your future career, not dreaming of your future career as a judge. And even if you are a young judge and go to a party, and someone takes pictures without you realizing and then publishes them, it was really as it happened, but it was completely innocent. Then you need protection as a judge. And this protection has to come from the court system, from the presidents, and the state has to make available also the remedies for this protection to make it effective. So I think the added risk is really because of this multiplication function of the social media, which we didn't have in the past. And there we have to think about the best solutions.
Just one comment, because it might be interesting. During one of these seminars, this one was in Belgrade, we did an empirical assessment. And among the judges that were there, and it was about 50 persons, most of them juniors, we put the questionnaire, anonymous question. First, would you rely more on a judge after having seen this or improper images, yes or no? Second, would you find worse if you saw it with one of the oligarchs in private, or it was one of the members of organized crime in that society, yes or no? And the third question was, before making an analysis or a judgment, would you read the decision? And it was very interesting because what we think damages so much, the image, for them, it was the worst thing, the worst. And what was more damaging, do you know what it was? Seeing the judge in private with the oligarch, because that was an indication for corruption, and that was even much more damaging the image of any judiciary or member of the judiciary than just having some party fun. So it was all. I think we have to address it, but we need data on perception of society, because we think this is improper, but maybe it's not so improper for the rest of the society or younger judges, no?
Before we conclude, perhaps we have questions or comments from the participants. Well, good afternoon. I am Dzintra Balta. I represent currently the Supreme Court, but I've been for a very long time at the regional court, and we have been thinking with the colleagues about matters of communication. I have a question or a request. What's your opinion? A judge, as a participant of social media, couldn't a judge benefit from it? And perhaps the whole judicial system could benefit from it. And also perhaps the discussion could be raised to a higher level in the social media. For example, our Riga Regional Court has its own Twitter account, and I believe that the users of social media highly appreciate it. There are discussions whether other courts should do the same. But we have wonderful these examples where judges are developing high-quality discussion on social media. Currently, we had criticism and also perhaps advice to self-restrain. But perhaps we could benefit from it. Perhaps we could also give some kind of message regarding values, and perhaps we could develop high-quality communication in social media. So what's your opinion on this?
In the Netherlands, we have used Twitter for our courts. And that's very much appreciated, because after, hearings with a lot of impact, we immediately send a message on Twitter, with the highlights, of course, not with what has been said, but with the highlights. Sorry? No recordings, but but information about, well, it ended and who appeared, or, well, and that we do that also. We have also, as a court, we are with LinkedIn. All courts in the Netherlands have the profiles of their, well, if you want to, their colleagues on LinkedIn, and that gives the possibility to also. Well, put some interesting message of Congress conference or books that you should read, or all professional and linked to our, well, to our profession as judiciary, of course. But there was a time when we didn't do it, because we do that now for 2 years, and we noticed that there was this well, in fact, demand from society. Everybody lets us know what happens, and you are quiet. So, as an institution, as a court, it helps us. It helps us. Yeah.
I would say also, I mean, it's one of the points in the recommendation of the Council of Europe, just to establish I wouldn't say a strategy of communication, but every court having a spokesperson. And the strategy of communication can be obviously linked via LinkedIn, via Twitter, or whatever kind of social network. What I would say, and we had precisely in several Council of Europe meetings with the persons who really know how to handle the media, and as long as it is done professionally, because otherwise you can really send a very misleading message and damage the whole judiciary. So the recommendation of Council of Europe, and one of the parts of the action plan, is introduce this professionally educated, preferably journalists with education in social media and communication, with knowledge of the law and what is going on in the courts, but not the other way around. Not a judge that has some knowledge on communication skills, no? And try to introduce it as at least in every court. Obviously, every court cannot have a spokesperson, because they cannot pay additionally a journalist, no? In that case, a judge should be specifically trained or seek advice to the spokesperson and the High Council of Justice in order to define the communication strategy. I fully agree that there is a driver to benefit for the judiciary to give an image, to enter into communication with the society, and using the communication ways the population uses right now. There have been a lot of issues regarding to blogs. Intranet blogs discussing decisions that affect the judiciary and so forth, that are very widely used in Spain, intranet, so only for the judges themselves. But some of those judges also go and publish blogs dealing with professional issues. Is this a good practice or not? I would say, depending on the quality of the blog and what is posted on the blog. I would say here again, caution, common sense, and if there are any doubts, please contact the relevant skilled person.
Good afternoon. I'm from the Riga Regional Court. I'm the president of the Riga Regional Court. We are one of the few Latvian courts that has its own Twitter account. And here's what I have to say. We should, however, discriminate between cases when a judge or a court employee posts a private message or private information on their social media accounts. And judges do have their Twitter accounts, and they do use them quite successfully in promoting the awareness on what the courts do and judges do for professional communication, if you will. And Rudit Vidas, also from the Supreme Court, is also a very keen user of social media. And then we also have court Twitter accounts or sort of institutional Twitter accounts. And we have also used Facebook as well for institutional communication, for formal communication, where we post only, very dry, formal information, and we are quite successful using or employing our Twitter account, because it is our media and we create the content, we post the content, we choose when to post the content, we create our own headlines, so there's no possibility to somehow spin it, and we can directly communicate to the people through our Twitter accounts. And here's my wish, or would like to urge my colleagues to think about this, because it's a great opportunity to communicate professionally on what courts do. And what I have also done is we have adopted instructions on how to use social media, and we have our own communication person, and they have to get my approval for any messages or on any posts, and we try to make sure that we have a diverse content on our account. For example, today's conference, we also advertised today's conference early this morning on our Twitter account with all the photos as well of the participants and what happened here. So you have to have an interesting content on the cases that we are dealing with, on what is happening in our profession, how do we build relationship with other courts, Supreme Court, Constitutional Court, with our counterparts abroad. So I think that modern technology and modern communication platforms give you, very vast opportunities if you're a keen user, if you're an expert user.
Do you have any comment?
I fully agree. I mean, it can be a very good way, on a very good driver to build up trust. And trust is built up on knowledge, and knowledge well communicated. If you are able to communicate and transmit the work you're doing, whatever the other media, official media or controlled media are saying about you, and you can a little bit counterbalance that negative impact upon what you are doing. Because, as I told this morning, there's the trend that politicians just put the blame and shift the blame upon the judiciary, and the judiciary that had to be discreet, silent, and exercise restraint in expression. There have been so many abuses. Who is to be blamed for every disaster in the country? The judiciary, no? And that creates problems for the judiciary and the distrust. This can be counterbalanced in order to really explain what you are doing and how well you are doing, at least in 90% of the cases. Of course, the important thing is do it professionally. Seek advice from experts and elaborate a common strategy, so that no court is just playing their own music.
And don't end up being defensive, because that is the risk. Yep. So, and therefore you need to develop a strategy. Well.
Vēl kāds jautājums?
Do we have any more questions from the floor? Any comments you would like to share?
Don't have any questions. We can go to the closing remarks, and maybe Wolfgang, you want to say something?
Well, what I can say is only that it was a great pleasure to be here today with all of you, and I appreciate very much your active involvement, more in some of the sessions, but nevertheless, I had the impression that what we offered to you today was of interest, and I hope you have the same feeling and think that what we have discussed today is really of relevance for your daily work, perhaps not every day, but nevertheless for your daily work as a matter of principle. And I would like to thank all of you, the speakers who have accepted to come, who have shared with us so many interesting aspects of judicial independence, more abstractly and more concretely. And all together, I think we have a round picture of what is important. And thank you, Anna, for the organization and for the cooperation.
Yeah. Paldies.
And I, as well, on behalf of the court administration, would like to thank all the speakers for agreeing to come here, for agreeing to come to this conference and share your knowledge with us. I think this has been a very good conference, a lot of takeaways we've got here, and we also got a philosophical insights and very holistic insights. Once again, Wolfgang, thank you very much for this initiative and for putting together the agenda for today's conference and getting all the speakers on board. Thank you very much also to the participants for staying so late on the Friday afternoon, but this only underlines that everyone has enjoyed what has been taught here, and I would like to thank Ellie, Nielsbeth, and everyone, all the technical staff who ensured that we have a smooth conference. Would like to thank also other technical staff for supporting the conference. This is untranslatable, I'm sorry. And I would like to wish everyone to enjoy holiday season, which is approaching fast. Would like to wish everyone a safe way home. Enjoy the weekend. Thank you.